It is 9 o'clock and I call this meeting to order. To begin with, I'll ask Mr. Nathan James on our staff to call the roll and establish a quorum.
Mr. Cobbins.
Here.
Ms. Cox.
Here.
Mrs. Hartgrove.
Here.
Mr. Holt.
Here.
Ms. Hartpool.
Here.
Mr. Jensen. Mrs. McInturf.
Here.
Mr. Mullenhour.
Here.
Mr. Morrow.
Here.
Mr. Wells.
Here.
Mr. Chairman Eby.
Here.
You have perfect attendance, Mr. Chairman.
Outstanding. I declare we do have a quorum and we're duly convened. This time I would like to recognize Dr. Sarah Morrison to give an overview of our workshop.
Yes, thank you, Chairman Eby. For those of you that were with us or tuned in yesterday, you know it was a full day. We had several conversations about important topics coming before the board, both today and at future meetings. We heard from colleagues at the department on updates regarding the ESA and IEA programs, various scholarship programs across the state. We heard from Allie Reed on the state board team on an update regarding charter authorizer evaluations. We're in our second cycle of that relatively new work. It's good to talk and see the improvements in that area. We heard from Martha Moore at the Department of Education on differentiated compensation and the various ways that districts across the state are incentivizing both the attraction and retention of effective teachers. We heard from our partners at Terra, our partners in research, I'll probably get the acronym wrong, but from Vanderbilt, Laura Booker, and her colleague on outcomes from the 2023 Educator Survey and various ways that as a state we can begin to think about what those responses tell us about the needs of our teachers and the pipeline of teachers to come. We had a brief update from Michael Derline as well on our team regarding the Licensure Coherence Project, which is a partnership with the Department of Education that we're excited to launch. Will give us a really intentional way to think about licensure pathways, licensure requirements. It will involve conversations with a number of stakeholders across the state, and that group will be making recommendations to me and to the board on future items related to licensure. And then we also had the beginning of what I know will be another full discussion today about some of the items before us on 3rd and 4th grade promotion and retention. So appreciate all the time that our staff and our board members, Commissioner Reynolds and her team put into ensuring that yesterday really prepared us for more good discussion and really student-centered decisions today.
Thank you, Dr. Morrison. Also, yesterday we had a few words given to us by our Chair Emeritus, Lillian Hartgrove. Those of you who don't know, this may be Lillian's final board meeting. We don't know that for a fact. But I just wanted to take a few minutes and say a few words about what she has meant to this board and to me personally. When I became chairman, I developed this acronym called LEARN, where L was to listen, E is to engage, A is to act, R is to respect, and N is to navigate. And I can't think of anyone who has done that any better than Lillian Hartgrove has over the last several years in leading this board. We will have another opportunity to more formally recognize her, but at this time I would ask everybody to stand and give her a round of applause.
Mr. Chairman, you surprised me. Do I have the permission to speak for just one moment?
My sister from another mister absolutely does.
My brother from another mother. I just want to say you totally surprised me and blew me away by that, and I thank you so much for the recognition, and it has been an honor, but more to come in the future, I'm sure, in terms of words from me, but not necessarily today. I don't know. You never know. Anyway, thank you.
Thank you. Okay. With that, I want to remind presenters to identify themselves by giving their title and their position when presenting. I also remind presenters if you use acronyms and jargon to please explain what those are so that we can everybody can readily understand what we're talking about. With that, we'll go to the first item, which is the consent agenda. Everybody should have the consent agenda for them. Do I have a motion to accept the consent agenda as presented?
So moved.
Motion by Mr. Mullenhour to accept, and a second by Vice Chair Cobbins. Any discussion? No discussion. All in favor signify by saying aye. Aye. Opposed? Motion carries. Next is automatic teacher licensure. Mr. Todd Madison and team.
Good morning. Todd Madison, Ryan Shanahan, Associate Counsels for the Board. First up, we have our automatic teacher licensure actions. State law and board rule require the automatic revocation or automatic permanent revocation of an educator's license for certain offenses and classifications set forth in law. These individuals have either been convicted of one of the specified criminal offenses or their conduct meets the classification as determined by DCS. As such, we recommend the approval of these automatic actions.
We have a recommendation. Is there a motion?
Madam Mr. Chair, so moved.
Mr. Morrow moves. Is there a second? Mr. Warren, Wells seconds. Any further discussion? If no discussion, then all in favor of accepting the recommendation as presented to us on automatic teacher licensure actions?
This is a
signify
roll
by
call?
saying- Oh, roll call?
Yes, sir.
This does require a roll call vote. Thank you. Mr. James, would you please give the roll call?
Yes, sir. Mr. Cummins.
Aye.
Ms. Cox.
Aye.
Mrs. Hartgrove.
Aye.
Mr. Holt.
Aye.
Mr. Jensen. Mrs. McInturf.
Aye.
Mr. Mullenhour.
Aye.
Mr. Morrow.
Aye.
Mr. Wells.
Aye.
Mr. Chairman Eby.
Aye.
Mr. Chairman, you have 10 ayes.
Motion carries. Next item, Mr. Madison.
Thank you. Next up, we have the individuals reported by the Department of Human Services. State law and board rule require the board to automatically suspend the license of an educator who fails to comply with an order for child support. The Department of Human Services has notified board staff that this individual has fallen out of compliance with their court-ordered obligations. As such, our recommendation is to suspend his license until we receive notification that he has come into compliance.
We have a recommendation for a suspension. Is there a motion?
So moved.
Mr. Jensen so moves. Is there a second?
Second.
Vice Chair Cobbins seconds. Is there discussion? If no discussion, all in favor of accepting the recommendation
Roll call.
for, taking this action, we will have a roll call vote. Mr. James.
Mr. Cummins. Aye. Ms. Cox.
Aye.
Mrs. Hartgrove.
Aye.
Mr. Holt.
Aye.
Mr. Jensen. Mrs. McInturf.
Aye.
Mr. Mullenhour.
Aye.
Mr. Morrow.
Aye.
Mr. Wells.
Aye.
Mr. Chairman Eby.
Aye.
10 ayes, sir.
The motion passes. On the next item for teacher licensure discipline actions, I understand that Mr. Milsaint is here to speak on his behalf, so we will pull his out. We'll address the others first, and then we will address Mr. Milsaint. Is that correct, Mr. Madison?
Yes, sir. So for the other items, that's items A through G and then I through M. These are the recommendations for license actions that are not tied to an automatic requirement. Each of these individuals has agreed to the proposed action on their license. The board's legal staff recommends approval of these items. We can take any questions that you may have at this time.
Are there any questions for Mr. Madison? Mr. Mullenhour?
Mr. Chairman, I just wanted to mention real quick, because I assumed that you wouldn't. I thought that you had a great deal of forethought and consideration in moving these items to the top of the agenda. And just for those who are watching, typically we hear these matters at the end of our meetings. And unfortunately, what that does is it requires that anybody who's coming to speak sit through 2 or 3 hours worth of meetings to be heard. So I thought that you just displayed a great deal of consideration in restructuring the agenda in this way, and it is how we want to treat anyone who wants to come and speak. We want to value their time, so I just want to recognize that.
I appreciate that. I can't take that credit. I think others had a lot to do about saying that, Mr. Mullenhour.
Whoever they may be, thank you.
I do think it's an excellent suggestion, and thank you for the legal team for doing that.
Mr. Chairman,
Yes.
the one thing that I wanted to state for the record is so that everyone understands, we have been given a lot of information, lots of files and data on each of these cases that are before us. And so we all have an opportunity to review those. And the staff goes through such a rigorous process back and forth, getting everything that they need, in addition to the fact that they provide us with information relative to previous cases, previous consistencies and things of that nature. So we're doing our best due diligence to ensure that we are consistent in the action that we take against a license based on the type of infraction or whatever the proper term is. So I just wanted to make sure for the record, they've done an excellent job of providing us what we need. And so we may not be asking as many questions when we're in front of you all because they've given us so much rich information. And we have opportunities to ask questions if we have them, even still after that. So anyway, that's all. I wanted to make sure you all do an excellent job in that regard. So thank you very much.
Thank you.
Very good comment, Chair Hartgrove. Any other comments or discussion? If not, Mr. James, would you please call the roll?
Motion.
Do we have a motion?
We
I need a, thank you, I need a motion. Do you have a motion by Mr. Wells and a second by Mr. Jensen. Now, call the roll.
Yes, sir. Mr. Coppins. Ms. Cox.
Aye.
Mrs. Hartgrove.
Aye.
Mr. Holt.
Aye.
Mr. Jensen. Mrs. McInturf.
Aye.
Mr. Mullenhour.
Aye.
Mr. Morrow. Mr. Wells.
Aye.
Mr. Chairman Eby.
Aye,
10 ayes, Mr. Chairman.
that motion passes. Now with that, we will then go to Mr. Nelson Milsaint. And I believe he's in the audience and would like to come and speak on his behalf. Is that correct?
Yes.
Okay.
Yes. Mr. Milsaint, you come to the podium, please.
Mr. Milsaint, you have 3 minutes.
Sorry. Good morning, everyone. My name is Mr. Milsaint. I'm from Florida. I've been teaching in Florida for over like 4 years, but originally from Haiti. So the reason why I'm here is just because when I came here a couple of months ago. So my cousin lives here. He been trying to tell me, yo, why don't you move in Nashville? I was like, well, I've been in Nashville before. Especially I was a full-time student athlete, played for this school, FI, Florida International University. But I was like, okay, sounds good. I'm gonna come here. And I was like, you know what, let me start looking for a job as a physical education teacher because I like the environment. And I was like, you know what, this would be a good thing to move, to experience like, you know, a new place, a new state. So I had applied for the certification here, but I found out it was denied. I was like, okay, why is my certification denied? But I didn't know exactly what was going on until they said that I'm pretty sure my certification from Florida was denied or reprimanded. But I was like, well, I don't know how this is possible because I got this proof right here on 7/16/2020. They provide me a 3-year statement. So now I had to take the test. I went back, I took the essay, I passed. But it was like a month later, I received my score, says, okay, you pass it. And I was okay, cool. So now they was like, oh, you're gonna have to take the full, there are 4 classes that I need to take to get my professional, which is the 5 years professional license. I was like, sounds good. I was like, why? I called the state. I was like, why do I have to take that? They was like, well, you're gonna have to because I didn't have it. Imagine I'm an education major. So I was like, okay, cool. And then later when I had received an email from them says like, oh, my score was invalid. I was like, why my score is invalid? They was like, well, my essay looked like somebody essay looked like my essay. I was like, how? So it was like, well, we're gonna have to do an investigation. What they did, I'm pretty sure. I don't know if they went to the test center, especially when you're taking the test. They have like a cameras, and for like each computer right there's camera on, and they have proctor as well. So now I was a UTD member. I spoke to the staff from UTD, and they took over my case. But I was still teaching. So they was like, well, they sent me a letter says I'm gonna have to sign this paper. I have to take the essay. I was like, no problem. I went back. I took the essay. I passed. And then they gave me on 5th, 2023, they gave me another 3 years statement eligibility to teach. Because imagine, I was teaching in 2021 as a gifted teacher. And 2022, 2023, I was a physical education teacher. So it is like, I don't really know what happened, but I called them. I was like, this is what Nashville said. You have a hold on my license. They was like, well, we don't have any hold on your license. All I had to do is just complete the courses, which is I'm taking them right now, currently taking 2 courses. And it was like, when you submit that to the State of Education, and they will give me my professional license. So they was like, well, I need to get in touch with you guys and to see what's going on. So that is the reason why I'm here. So I just want to, I also I also like, bring the proof with me, which is my statement from 2020 to 2023, and that's the one that I have from 2023 to 2026. So therefore, I'm still eligible to teach if I go to, let's say I go to Florida right now, they will hire me on spot.
Thank you.
You're more than welcome.
Ms. Nellis, would you like to make a few comments?
Excuse me, sorry, thank you. Mr. Chair, P. Danielle Nellis, Deputy General Counsel for the board. We recommended denial based on the information we were provided from Florida. Florida, and we've checked with them multiple times, Mr. Milsaint's license is still in denial status based on, as he's described, what they perceive to be fraudulent behavior when he took his exam. And so they still have his license denied. They have not granted it based on the information that we have received in our conversations. And so, and I should probably backtrack, he submitted an application to Tennessee in August and September. He was denied, and he was denied by this board in November. He submitted an additional application. On those applications, the initial ones, he failed to note in his personal affirmation that he had been denied. And so that would be in violation of our rules. On his most recent applications, he clicked the personal affirmation 59 separate times, and we checked with our technical support, Randa, to see if that was a glitch or if that was something that somebody had to do each and every time. And so it looks like he clicked it 59 individual times. And on those, he did, as we've indicated in the information provided to you, he did indicate that he was disciplined, but he failed to appropriately indicate he had a license denied for disciplinary reasons. And so as it stands, we do not have information to indicate that he has a valid license in Florida. We also have his multiple personal affirmations that are not fully forthright as we perceive it, and we are therefore recommending that this board deny his application and prohibit him from applying for an additional year. Though I certainly understand, and this is new information to us, Mr. Milsaint is putting forth that he is currently eligible and that he has cleared up all of his situation in Florida. That information has not been presented to us. It is not consistent with our conversations with the Florida board. But if for some reason he were to present that information, I certainly understand how this board may want to take that up and alter our recommendation in some way.
Yes, Mr. Mullenhour.
Thank you, Danielle. I just have a quick question. So I'm on the Florida website right now, and Mr. Milsaint, there's nothing in the public record that they offer that would suggest that your license is current. The licenses that are shown here are shown as being expired, and you can take that up with Florida. I think that's probably between you and Florida. I'm just saying that looking at their database right now, what they make publicly available does not indicate that you have a license. My question, Danielle, is this: if regardless of the truth of statements that have or have not been made in the past, if he's not currently licensed, if his license is not active in Florida, my understanding is that we don't have the ability to suggest that a license is granted today. Is that correct?
The types of licenses that he has applied for, so previously he applied for an out-of-state practitioner license, and that was denied in November. The application he has before the board and department currently is an out-of-state occupational license. It's our understanding that based on the information he has submitted, he is actually not even eligible for the license type that he submitted information for. And so we believe that the department would eventually review it if this board were to grant his application, and then they would reject it because he is not eligible. He does not have the qualifications for the license that he applied for.
Just, okay. Dr. Morrison?
Mr. Chairman.
Yes, Mr. Holt?
Danielle, I'm trying to understand whether each of these, it seems like different grounds are independently sufficient to adopt the recommendation, one being the non-disclosure,
Yes.
and the other being the lack of a current licensure in the state of Florida. Could you speak to those as if, for example, if the state of Florida were to grant him a license in a month, for example, I know the recommendation is that we prevent him from reapplying here for the next year. Would the fact that there was this non-disclosure in his prior applications be cause in and of itself to adopt that recommendation of the 1-year ban on applying?
Yes. Our rule 0520-02-03.095A8 reads, an individual holding an educator's license who is found to have falsified licensure documentation shall be subject to a disciplinary action within the range of revocation or permanent revocation. We also have the ability forgive me, I need to hop down to the correct rule here. An individual, in that same rule 8A, if an individual indicates an affirmative answer on the personal affirmation section of the application for Tennessee's educator license, the burden is on the individual to show why the license should be issued, and we have the authority to reject that application. And then also in that same rule 8B, it provides there's a rebuttable presumption that an individual applying for an educator license who has committed an offense that would subject him, sorry, that's the wrong one. Forgive me. But in short, in our rules, we do have the authority, we have the authority to, based on his actions out of state, reject his license. And so even if he went back to Florida and was granted a license, we would be able to make this recommendation, stand by this recommendation, and hold out for the remainder of the year that he would not be able to apply.
My understanding was that when you cited that falsification language, that the claimed falsification was in his application for licensure in the state of Tennessee. Is that
Yes.
correct?
That is correct. In his initial personal affirmation and then the subsequent, the one that's before the board right now, he failed to disclose in his personal affirmation. So we would be able to take action based on that.
And the failure to disclose was, if you could help me, although he he said that he had some disciplinary issue in Florida, he did not say that his license had been denied for that reason?
He did not indicate that his license had been denied here initially in November based on the disciplinary actions in his second round of personal affirmations.
Okay, thank you.
Other questions? Mr. Jensen?
There is a second issue of not being qualified for what he's applied for. Did I hear that correctly?
Yes.
Okay, thank you.
Mr. Morrow?
That's clarification, but after a year, if it resolved with the state of Florida and he went through the year of, since he withheld information, he then could still begin a reapplication process.
Yes.
Okay.
Yes, Mr. Wells?
So the 1 year, is that, do we have to do a year? Is that in rule?
We do not.
And so you all recommended the year because this is what we've done in the past, or what?
We recommended the year based on the multiple applications entered by Mr. Milsaint, his presenting information that was, to our understanding, fraudulent, right? And though we certainly understand the statements he's made today and painting them as a mistake or an oversight or misunderstanding with the Florida board, our perception is that they have simply not been true. He's also submitted some paperwork to us as a team indicating that he was eligible for a license, but he is not, as we have, Mr. Mullenhour has pulled up, he doesn't have a license. Our understanding in conversations with Florida is he is not eligible for a license. So we have this repeated pattern of behavior where we believe it would be appropriate to prevent him from applying for a year. But that is not a requirement, and this board can certainly adjust make whatever decision that this board would like to make.
Any other questions?
Mr. Chairman.
Yes, Ms. Cox?
So, correct me on this. If Mr. Milsaint were to get his license approved in Florida and after a year he reapplied and he were still in the incorrect pathway, his licensure would still be denied again?
we would not necessarily have a basis to deny it because there was no discipline or fraudulent behavior associated with it. However, the department might reject that application or encourage him to apply to the correct pathway based on the information that he has submitted.
Further questions? Mr.
Mr.
Mullenhour.
Chairman, as our former chair indicated, you know, every one of these files comes with sometimes voluminous context. So, you know, there's a lot of documents. The board's legal team tries to help us understand what the truth is, what the facts are, so that we can try to make an appropriate decision. I would underscore a couple of things here. One is, you know, the goal is to make sure that the kids across Tennessee have teachers in the classroom who are honorable, who are honest, who provide information forthrightly, and who are going to protect the kids and be good role models for them. That's the objective. That's part of why these processes are in place, Mr. Milsaint. I would agree, although this hasn't been stated, you know, sometimes it can be confusing. Sometimes the forms and the pathways, and we are aware of that issue. Sometimes that can cause confusion. And sometimes that confusion can look like someone was trying to provide incorrect information or withhold information. You know, I'm not going to suggest either way whether or not that has happened in this particular case, other than to simply say the team has a really good process for making sure that we vet people carefully, and that if someone isn't telling the truth, that we identify that fact and we take that into account heavily, because we want people in front of the kids who are going to be good role models and speak the truth. So my understanding of our vote today is, you know, we really don't have an option to grant a license today, because it's not, it wouldn't fit within the requirements of the law. And Danielle, please correct me if I'm mistaken here. The question really is, you know, do we deny it for do we deny it today, or do we deny it for some longer period of time? I think that's the pivotal question that we're faced with today. Danielle, is that correct also?
The board has the power to grant. I want to kind of split that hair
Grant the ability to apply, but then it will be denied subsequently by the department.
Exactly.
Yeah, okay. So, you know, Mr. Milsaint, I would say this. I'm grateful that people like you and others are willing to come and teach kids in Tennessee. But there are going to be strict requirements, and this may have been a matter of confusion on your part. I'm not really sure, but you're going to have to get that straightened out, and you're going to have to make sure that the information you provide is 100% accurate if you have a hope of getting a license, because we're not going to grant licenses to people who are not telling us the truth. And the file would suggest that either there is confusion or that you're not telling us the truth, telling our team the truth. And then that's a real problem.
Thank you, Mr. Mullenhour. Are there any other questions for Ms. Nils? We have a recommendation from our legal team for denial with stipulations for the reasons provided here in this discussion. Is there a motion?
So moved.
Mr. Mullenhour moves to accept the recommendation. Is there a second? Second call for a second. I'll second the motion for, to arrive at a vote. Is there further discussion? Mr. James, would you please call the roll call?
Mr. Cobbins.
Aye.
Ms. Cox.
Aye.
Mrs. Hartgrove.
Aye.
Mr. Holt.
Aye.
Mr. Jensen. Mrs. McInturf.
Aye.
Mr. Mullenhour.
Aye.
Mr. Morrow. Mr. Wells.
Aye.
Mr. Chairman Eby.
Aye.
10 ayes, Mr. Chairman.
The motion passes. Thank you.
Thank you, Mr. Chair.
Ms. Lee. Next item is action items on first reading. Ms. Jennifer Jordan, Special Ed Programs and Services Rule.
Good morning, Board. Commissioner. My name is Jennifer Jordan. I'm Assistant Commissioner of Special Education and Intervention Programs, and I'm here today to share with you the Special Education Programs and Services Rule 0520-0109.12.18 and 0.19 revisions to that rule. The Individual with Disabilities Act requires LEAs to include appropriate measurable post-secondary goals to training, education, employment, and independent living skills, as well as the transition services and courses of study needed to assist the students in reaching their goals within the first IEP that will be in effect when a student turns 16 years old. The State Board of Education Special Education Programs and Services Rule, Chapter 0520-0109, previously required LEAs to develop a 4-year plan of focused and purposeful high school study, including any necessary transition services that connected the student's goals for high school to the student's post-secondary goals no later than when the student turned 14 years old or began 9th grade. In 2021, the rule was amended and the requirement for developing a 4-year plan of focused and purposeful high school study was eliminated. Currently, State Board of Education Rule 0520-0109.12b only requires LEAs to include age-appropriate transition assessments to include, at a minimum, education, training, and employment for students age 14 and older. In an effort to increase the percentage of students with disabilities who enroll in post-secondary education or training program or who are employed, this item revises Section .12 of the rule to once again require LEAs to include courses of study, transition services, and annual IEP goals that will reasonably enable the student to meet the post-secondary goal in the first IEP that will be in effect when the student turns 14 years of age. Additionally, this item makes 2 further minor proposed edits to Section .18 and Section .19 of the rule to align them with state law. First, Impartial Due Process Hearing Rule 0520-0109.18 currently confers jurisdiction upon the state's administrative law judges to hear complaints arising under the Individuals with Disabilities Act and rules of the State Board of Education. This proposed amendment clarifies the state's administrative law judges also have jurisdiction to hear complaints arising under state special education statute and in alignment with Tennessee Code 4910-606A. Second, Civil Action Rule 0520-0109.19 currently allows parties filing due process complaints to bring an action in court of competent jurisdiction. In accordance with Tennessee Code 45322 and Tennessee Code annotated 4910-601. This proposed amendment would strike the reference to Tennessee Code annotated 4910-601 since this statute merely establishes the procedural safeguards for students with disabilities. The State Board staff will hold a rulemaking hearing between the first and final reading to collect public feedback. TCA 49.1-12 requires the department prepare a fiscal analysis of any policy, rule, or regulation proposed to the State Board. This proposed amendment to Rule 0520-0109.12 would require LEAs to develop and implement IEPs that include transition services and measurable post-secondary goals 2 years earlier than IDA requires. These costs are expected to be minimal and could be implemented by LEAs without additional staffing. The Department of Education recommends acceptance of this item on first reading. The SBE staff concurs with this recommendation.
Thank you, Ms. Jordan.
Absolutely.
Are there any, can I first have a motion to accept the recommendation?
So moved.
Vice Chair Cobbins moves. Mr.
Second.
Morrow seconds. Now discussion. Is there any questions? I'll just make one comment. I really think this is moving things in the right direction
Yes, sir.
down to age 14, and I would hope that non-special ed students would also have equal counseling and guidance, et cetera, to help them in their long-range plans. I think our high school and beyond plan starts working in that direction.
Agree, and this aligns with the High School and Beyond plan and also the innovative school models. There's also that career exploration that's happening in late elementary and even into, middle schools. Because in fact, this is the middle schools and before is when you start really putting students on a pathway in the correct trajectory and making sure their conversations really think about what the student's aptitude is and what their abilities are and what opportunities and experiences we need to provide them to meet their goals. So, yeah, we're happy to see this return to the rule.
Thank you, Ms. Jordan.
Mr. Chairman,
Yes, Mr. Morrow.
just a question. What, I think this is fantastic for all the reasons y'all just said. How will the communicated change, or how will the change be communicated to families? Just where there's sort of the checks and balances so families can advocate if this is delayed getting into the districts or the LEA's hands, that they're aware that this is now something that they have a right to have access to and should be a part of their planning. Just what's the communication process?
And so we have a pretty comprehensive communication process with multiple stakeholders. We meet monthly with our directors of special education across the state. So we try to share that information with them directly. Anything that impacts their work, we would like for them to engage in conversation with us and at least hear about it first. Additionally, this rule was already in place, and to be honest, there were some that didn't know it was changed. They didn't know it had been eliminated. So many of our conversations and practices in the schools, they're still engaging in those conversations. It just moves it into an official plan. We also have several contracts through our Tennessee Technical Assistance Network, which is basically a network of resources across the state that are no cost to districts and families. We have a Transition Tennessee contract with Vanderbilt, and really the sole purpose of that contract is to support districts with developing high-quality transition plans. So we will lean into that contract. We also have a family engagement contract with the ARC of Tennessee. So they're really good partners in providing family-friendly information. So they take our policies and our rules and then roll those out to families. Obviously, we want to get to the practitioners. And so we have transition conferences that are this summer that are open to the practitioners, the individuals in the schools that are actually writing the plans. So I think with coordinated effort, we will hopefully get this information out to stakeholders. So that is the plan. And again, we've already started talking about it as a possibility and a potential, and the need to really intervene early with these students. You're welcome.
Any other questions, Ms. Jordan? No questions. We have a motion and a second. All in favor then of accepting the special ed program services rule on first reading, signify by saying aye. Aye. Opposed? Motion carries. Thank you, Ms. Jordan. Next item is literacy and specialty area standards for education preparation policy. Ms. Brooke Amos.
Good morning. Brooke Amos, Assistant Commissioner of Human Capital with the department. All educator preparation providers, EPPs, and the specialty area programs, SAPs, that lead to licensure shall be approved by the state board. And those programs must ensure that the candidates have opportunities to attain core knowledge and skills, have robust clinical experiences, and meet other standards, procedures, and requirements, all established by the board. EPPs shall ensure that all programs that lead to licensures are aligned to all applicable literacy standards and SAPs. The Literacy and Specialty Area Standards for the Educator Preparation Policy, 5.505, defines the required standards for literacy in each of the specialty area programs. This item provides revisions to the aforementioned policy, 5.505, adds the AgriScience 612 program components and the specialty area standards into the Career and Technical Education academic SAP. Additionally, a revision is being made to the agricultural education standards to remove AgriScience 612 and replace it with Agricultural Education 612, which fixes a clerical error. These revisions ensure that there are STAP standards corresponding to both the AgriScience 612 and the Agricultural Education 612 endorsements. Revises the special education SAP program components to reflect the new Council for Exceptional Children, CEC standards. clarifies the health and physical education program component to reflect that the educator preparation programs for health and wellness education shall be aligned to the Society of Health and Physical Educators, or SHAPE, initial physical education teacher education standards, and finally removes the early childhood foundational literacy skills standard 1.2 term entomology and replaces it with the term etymology, which was a clerical error. The department recommends the acceptance of this item on first reading. The State Board staff concurs with this recommendation. Thank you.
We have a recommendation. Is there a motion to accept? We have a motion by Mr. Jensen. Is there a second?
Second.
Chair Hartgrove seconds. Discussion, questions for Ms. Amos? No questions. We have a recommendation and a motion and a second. All in favor of accepting the literacy and specialty area standards for education policy signify by saying aye. Aye. Opposed? Motion carries. Thank you, Ms. Amos. Next item, standards review policy. Michael Durline.
Good morning. Michael Durline, Deputy Executive Director of Policy and Research with the State Board. This item is the Standards Review Policy 3.209, which details the purpose and timeline for the review of all academic and career and technical education standards. Revisions to this policy include alignment to a new state law that shifts the cycle of core academic standards review from 6 years to 8 years, and also includes language related to the Department of Education standards reviews, so all of those non-core academic areas and career and technical education standards, codifying a timeline for those. So you'll see that that timeline varies depending on the content area, with CTE, computer science, and personal finance being reviewed on a more frequent basis. And this increases transparency regarding those cycles. With that, I'd be happy to take any questions you may have.
We have a recommendation on standards review policy. Is there a motion to accept the recommendation?
So moved.
We have a motion by Chair Hartgrove. Is there a second? Second by Mr. Wells. Discussion, questions?
Mr.
Chair
Chairman,
Hartgrove?
I just wanted to ask Michael if you would help everyone understand the rationale for why we're moving from 6 years to 8 years. I think that would be helpful for people to understand. Thank you.
So under the 6-year cycle, essentially the start of the review process for the core academic areas only allowed those expert educator advisory teams 1 year with the standards before they had to determine what revisions might be necessary. Not enough time. And so shifting to the 8-year cycle will allow for 3 years of experience with those standards.
Can you explain?
It also saves money, saves the state money, which is a rarity.
Can you explain a little bit better why 8 years only, or 6 years only allowed 1 year? Can you talk a little bit about that timeline?
Yes. So the process by which we review core academic standards, it takes roughly 18 months. Following that 18-month process, the Textbook and Instructional Materials Commission takes about a year to review textbook and instructional materials that then come before you all for approval. Following that, districts have to determine which materials they will purchase and adopt. So that process takes quite a bit of time. And then you have to then start new process just a year later. So it's kind of a lengthy but rigorous process. But allowing 3 years as opposed to 1, I think will be beneficial.
Thank you. I have one other question. Why are the CTE and computer science, personal finance standards on a 3-year cycle then instead?
Yeah, my understanding, I think with those there are rapid changes. Certainly in CTE and computer science, I'm less familiar with personal finance and the world in which that lives. But I always like to note that our computer science standards were approved, I believe, last in October of 2022, and ChatGPT was introduced in November of 22. So already sort of some considerations there in an ever-changing space.
Good, thank you. Any other questions? We have a motion and a second then to accept standards review policy. All in favor signify by saying aye. Aye. Opposed? Motion carries. Thank you, Mr. Durline. Next, graduation requirements rule.
Thank you. Tennessee State Board of Education Graduation Requirements Rule 0520-01-03 outlines the academic and instructional requirements for courses and programs of study within public education. This item includes a revision to remove the requirement that students take a mathematics course or approved mathematics course substitution in each of the 4 years of high school. And under this proposal, students would still be required to take 4 credits of mathematics, but could do so within a 3-year period. Removing the 4-year requirement will provide students with flexibility to take courses aligned to their area of interest or pathway during their 4th year of high school. This may include mathematics adjacent courses such as STEM or CTE courses, or courses that are better aligned to their particular field of study. This revision also includes an addition of Cambridge International Education on the criteria list for graduation with state distinction, and clarifies or cleans up some issues related to credit assignment for physical education, lifetime wellness, and substitutions for JROTC. State Board staff will hold a rulemaking hearing between first and final reading to collect public feedback, and with that, I'd be happy to take any questions you may have or entertain a discussion.
Thank you, Mr. Derline. Since this is the item that I have brought forth with regard to my special item of effort, I will make the motion to approve this rule. Have a motion. Is there a second?
Second.
Our student member, Ms. Cox, seconds. Thank you. Let's open this up to discussion. I understand we'll probably have some pretty good discussion on this. Mr. Morrow.
Sir, I understand the flexibility, why you would do that. I mean, all of those things philosophically. Well, I guess my fear is the unintended consequences, right? So right now, I mean, our flagship University of the State is highly selective. And I just have some fears that if a student transcript does not have a math in a student's senior year, that is going to make them less competitive as they're looked at, right? I mean, and so that's sort of one concern of just reducing the level of competitive advantage that a transcript with 4 units of a high school math would have. I think secondarily, just in education, most colleges require mathematics as a part of their general ed curriculum, and you know, math is one of those perishable, at least for me, it is a perishable skill, where if you don't use it, you tend to lose it. And reading through some of the THEC conversations, that there's a significant concern by our math programs within our universities saying, hey, they're not exactly crushing it in math now. What would happen if they don't have this as well? And then sort of the third layer, which is, I guess, adjacent but related, that Chairman Hartgrove was talking about, what then would happen if we also take out Algebra 2 as a requirement? And so with math, just on the educator side, with math being such a specific, like what you take in 8th grade or in 7th grade sets a course for the next 7 years and really projects out where you're going to be able to get into college. And so just in between these readings would be really, I really want to have some good evidence from our universities that we are not, with a good desire for flexibility, for expertise, for allowing students the flexibility to be, which I agree with, like take a computer science instead of a 4th math, go to physics instead of a 4th math, but just making sure that everybody is synced up from higher education to secondary education to middle school education, that there is an alignment of expectation and aligned, protecting students who at 14 are going to make decisions with their parents that will have a significant outcome when they are 18 and going to college. That's synced up and tight. So over on this side, we're really trying to give kids greater options, greater flexibility, greater meaningful educational experience as a secondary ed student that doesn't have a negative and unintended consequence on their college application and college readiness. That gets somewhat determined around 7th or 8th grade when you start looking at, am I going to take algebra as a 7th grader, geometry as an 8th grader, or 8th grade as an algebra as an 8th grader, and those things. So that's just my, philosophically, like the idea, sort of as a practitioner, have some fear of the unintended consequences.
Thank you, Mr. Morrow. I will give you my thoughts on that. And I understand what you're saying. I'm going to ask Ms. Harpool to also speak because I've talked to higher ed about this. Me being an engineer, I firmly believe in the importance of math. And But I also believe the value of providing flexibility to our high school students on what best meets their requirements of what their needs are. And I had a conversation with Mr. Chris Whaley, the president of Roanoke State Community College, and he's strongly supportive of this motion. And his perspective is they have students who are in the middle college program who complete their math for their degree, for their associate's degree and their four-year degree by their junior year. They had a student who wanted to be a pharmacist, and he wanted to take some extra chemistry classes or something in his senior year. He couldn't because he had to take another math class. So I think if there's substantive counseling, guidance, people understanding ramifications and why they're doing what they're doing. I'd like to also hear from Ms. Cox, who seconded this motion, being a student, her thoughts on it. But I think this provides us the flexibility, and those students that take algebra in 7th or 8th grade are likely ones that are going to be taking math throughout and taking technical courses like engineering, which doesn't count as a math class, or classes that have math content. So I think everybody I've talked to, I think this gives us flexibility, gives the students flexibility to be able to meet that need. Let me ask Ms. Cox to speak, and then I'm going to ask Ms. Hartman to speak.
Thank you, Mr. Chairman. So I have a couple thoughts in response to the things that you're concerned about. So as a current senior who's in my 5th year of math, I took Algebra 1 in 8th grade. I've experienced two of the very specific things you addressed, one being that I haven't been able to take another class that would be more in line with my current college career where I currently stand because I've had to satisfy the current graduation requirements and take a 5th level math. However, one of the math classes I took last year to, again, satisfy the 4 years or the 5 years to meet one every single year, that class ended up being what pulled my GPA down by a couple points. So your concern is having all of those credits on your transcript when applying for colleges. However, trying to force students into taking an extra level or credit of math whenever they may not originally have to could be what hinders them from performing so well in those college application and scholarship application processes. Something from my personal experience is what's been impacted by that. So I see the concern. However, Algebra 1 does also, if you take it in middle school, it does still transfer onto that high school transcript, so it will still be the 4 math credits on the high school transcript when applying to colleges.
Thank you, Mr. Cox. Ms. Harpole, we've talked a little bit about this, and I know you've talked to higher ed more.
Yes, sir, Chairman Eby. So in June of 2023, at your request, we spoke to the chief academic officers of all the public institutions, so that's our community colleges and our universities, asking them 2 things. Would having 4 credits rather than 4 years of high school math impede a student's application or placement in their institutions? And in both instances, the chief academic officers indicated no, that it would not impact either their entrance or their placement in math. That being said, all of them echoed some of Mr. Morrow's concerns about you don't use it, you lose it, and the importance of the high school counselor to make sure that a student is aligned to what their path needs to be. And noting that a STEM heavy, if a student's taking Chem 2 instead of that 4th math and has already been through that rigorous math coursework, they're probably gonna be okay. But really just emphasized that having that one-on-one counseling for the student will be extra important. However, it would not impact either the placement or the admissions to the institution.
Thank you. Other questions or comments? Mr. Morrow?
Yeah, so I agree philosophically with this, actually. I really think it's great to give flexibility as someone who had to take lots of unnecessary math classes for what I was interested in. So I guess then my question is, it's just putting more pressure on counselors. So that the result is just, hey, this is great, but we got to make sure the advice we're giving a 14, 15-year-old family as they set out a 4-year plan aligns with their post-secondary aspirations, correct?
Yes, sir. So
I guess then it would be really important to talk to the schools just on caseload of counselors, right? So if you look at a 2,000 student high school, I don't know how many students are in your high school, but just that if there's a family that may not be fully aware that there are the resources within the counseling program to be giving solid advice, not 500 kids per counselor who's just trying to, who's overwhelmed with the numbers, right? So it's like the more tailored we can create the educational pathway, the better for the student. However, then the counseling and the advocacy work that's going to be done by the school counselor will have to match that, which makes it more tailored to the individual, which is just going to take more resources for the counseling, which I think is needed. I think we're very understaffed in counseling, but because it's turning sort of your traditional guidance counselor who's helping with master scheduling and all of those things to being a college counselor that is very precisely looking at what 5 options a student wants to potentially go to for college, how we line up their 4-year plan with those aspirations, and really being specific about it. So again, it's going to just give local, it's going to give LEAs and their counselors significant pressure to get that right. So when a kid's in their 4th year, they don't look up and say, well, wait a minute. So it's just, again, I agree with all of those things you guys are saying. It's just like we got to make sure that the counselors are then getting that right, and we're protecting them from an unintended consequence. Because, there's 3.8 GPAs and 26 ACTs that are not getting into UT now, right? Like there's really good test scores and really good GPAs that just aren't getting in. And so want to be careful that we're not, harming kids unintentionally while trying to give them more agency and opportunity, which I'm for.
I'll say this, Mr. Morrow. I think it also is incumbent upon us in higher ed, me, the executive director, Gentile, to communicate this out when there are policy changes from the board of what they can expect from students, and or if they want a 4th year math, to articulate that. They haven't had to because this was what the rule was. They didn't have to put that out. They could talk about a holistic admissions process. So it might be that it's incumbent upon higher ed to make sure that they are more transparent about what their expectations are, and that strength of schedule might not be enough information for students to access on the front end about what the expectation is for admission. So I think communication on the part of higher ed will also be important as any of the high school graduation requirements change, to make sure that higher ed is doing their part to inform students.
I think if you go back to your comment with regard to counselors, to me, this is an important aspect of the counseling. Go back to the rule we just passed, Special Education Program and Services Rule, which brought that counseling back to age 14. I'm glad we have that for IEP. It would be great if we have that for all students. And if we can allow
High school and
counselors.
beyond plan. Let me just throw that out there.
Pardon?
I think the high school and beyond plan.
High school and beyond plan,
Yeah.
exactly. Thank you. So if we can allow counselors to do their job counseling, then I think that would help along the process too. So, we put a lot of demands on them, but to me, this is exactly the type of thing that we should have our students be able to talk to counselors about. So.
Excuse me, is there a rule on threshold of counselors per students? Do we have that? Do we know what that is off the top of our
Well,
head?
there's a national recommended ratio, and then we're usually above that. And part of it is around, resources and how
Right.
much. And so it's often something that the former BEP review committee, now TISA review committee, would recommend to the General Assembly and to the governor to increase the funding to bring down that ratio. But that's often the biggest barrier, is the funding to staff at the nationally recommended ratio.
So our average is above the nationally recommended ratio. Okay.
Mr.
Any other-
Chairman.
Yes, Ms. Cox.
One thought about the issue of putting pressures on counselors, though, is if we're pulling off one requirement, then would it not be easier for them to work with student schedules and trying to fit in what classes that student would rather take as far as what would align better, instead of trying to work in all of the required ones?
Yes, and I'm not talking about building the master schedule. I'm just talking about counseling the family as they're entering into high school and building a 4-year plan of like, hey, if you want to go to, Tennessee Tech and you want to do a degree in engineering, what are the courses you want to take? If you want to go to UT Martin, but you want to do social work, what are the courses you're going to take? And so it's just trying to align a student's, as formed as a 14-year-old could have of that, right? Like, just that there's not that they're able to sit down with you and your family and say, hey, what do you want to do? And what is the best coursework trajectory or the best 4-year pathway we can put together to make sure that you have every advantage possible because a lot of our universities now in Tennessee are nationally competitive. There's nationally people are wanting to come to our universities, and so you're not just competing against other Tennessee students, you're competing nationally now in a lot of these seats. So just make sure that we're making that advantageous, not disadvantageous.
Good. Any further questions or comments? We have a recommendation and a motion on first reading to accept the graduation requirements rule. All in favor signify by saying aye. Aye. Opposed? Motion carries. This is a perfect example, Ms. Cox, of why we have you on this board, because the students bring a perspective that the rest of us don't have. Thank you, and thank you for your comments. Next item, uniform grading system rule. Mr. Michael Durline.
Let's get to hang out. Thank you. Uniform Grading System Rule 0520-02-03-.02 establishes the statewide uniform grading scale to be used by LEAs for students enrolled in grades 9 through 12 for the purposes of application of post-secondary financial assistance administered by TSAC. This item revises the percentage points used to calculate semester average grades for dual enrollment courses, moving it from 4 to 5. I wanted to thank the partnership with THEC on this. I know it's something they've been interested in pursuing for a while now, so I know Victoria Harpool could probably speak to that a little bit. But it is a fairly straightforward recommendation, but I'd be happy to take any questions you may have.
We have a recommendation. Do I have a motion to accept?
So moved.
Vice Chair Cobbins moves. Mr. Jensen seconds. Questions? Ms. Harpool, would you like to make any comments on this, or no comments?
At the Higher Education Commission, so this is the grade point average that is used to calculate the HOPE GPA. And so we're really excited to be in a position now that we can look at the dual enrollment, actual college participation in the same way that we would look at a college proxy course like AP and IB, to, if the state's making a bet on what students will be successful in post-secondary, having those actual post-secondary be on an even playing field. So we're excited about this change.
Thank you. Other questions or comments?
Mr. Chairman,
Ms. Cox.
I hope I'm allowed to say this. I like this. I wish I would have had this. Because I've taken almost more dual enrollment classes than I have normal courses, or like standard courses. And I've taken AP classes too, and occasionally the dual enrollment courses are at the same course load as the AP courses I was taking and weren't getting the same amount of points. So I wish I would have had this.
So I have one question. Can we make this retroactive?
I asked our general counsel, and unfortunately, no.
Well, just know you're doing this for the future. Yeah. Any other questions? We have a recommendation, we have a motion and a second. Then all in favor for approving the uniform grading system rule, signify by saying aye. Aye. Opposed? Motion carries. Next item, hearing procedures and public meetings rule. Ms. Angie Sanders.
Thank you, Chairman, members. Angie Sanders, General Counsel for the Board, presenting to you on first reading a rule titled Hearing Procedures in Public Meetings, 05200901. In this rule, we are renaming this chapter and establishing a new rule governing requests to speak at public meetings. The title of the chapter has been amended, and we have added a table of contents. Revisions to Rule Section 01 add a title for that rule where one previously did not exist. This rule has not been updated since 1979. So it is high time we looked at it. We also realized that the citation to the Secretary of State's rules that the board has adopted for contested case proceedings, that citation needed to be updated. So we've done that. A new Rule Section .02 has been created to outline requirements for the public to request to provide a public comment at a State Board of Education meeting. Currently, these requirements live in State Board policy. However, in compliance with recent court decisions, these procedures need to be moved into a rule. Language from our board meetings policy has been largely taken directly and put into this rule, but we have made a few additions and clarifications that I'll review for you. Requests to speak are limited to meetings with actionable items on the meeting agenda, and that's in alignment with Tennessee Code. The 48-hour requirement that we currently have in our policy about providing notice of a request to speak at the meeting has been amended to include an exception for persons who are seeking to provide a comment on an educator license action. However, it does state that you cannot provide a request the day of the meeting. You have to give us at least some advance notice that you are going to request to speak. We have added a limitation of 10 speakers per state board meeting. However, there is also an exception there for educator license discipline items. And that, again, is just to make sure that we're protecting the due process of these educators, that they get their time and their place to come and speak. We've provided examples of what disruptive means with regard to the prohibition on disruptive behavior. Clarified that comments are not permitted at disciplinary appeal hearings held by the board in accordance with our rule in the Administrative Procedures Act, but I do want to point out that does not include the educators. The educator would be a party to that appeal. They would still be able to provide a public comment. This is also in accordance with what the law says, so we are just tracking that. We will hold a rulemaking hearing between first and final reading, and I'm happy to take any questions.
I think we have a recommendation. Do I have a motion to accept that recommendation? Mr. Jensen moves. Do I have a second? Mr. Mullenhour?
Second, and then I did have a question.
Okay, Mr. Mullenhour.
Thank you. Angie, just to clarify, from a due process perspective, if there's a licensure matter, let's say that there's 11 licensure matters, I'm assuming that there's a provision in here that would allow all 11 of those to be appropriately heard.
That's correct. In the section that limits it to 10 persons, it states excluding requests to speak with regard to an educator license. That's the first part of 2B.
Okay. My question is then, are there any circumstances outside of that one exception that we need to account for here? I just want to avoid a situation where there's some other due process obligation, there's an obligation to provide due process that might fall outside of this exception.
I will make sure. There have not been any that we've identified up to this point, but we'll definitely make sure before final reading that there's no other provisions.
Thank you.
Mr. Jensen?
My question is about the same thing. Educator only, so it's restricted to the educator? What about legal counsel?
It says educator or their representative.
Thank you.
Any other questions? We have a motion and a second to accept the hearing procedures and public meetings rule on first reading. All in favor signify by saying aye. Aye. Opposed? Motion carries. We're going to go into the final reading, actions for final reading, go through about three of these before we take a break. So first item is Miss Angie Sanders while she's up there, non-public schools approval process.
Okay. Thank you, Chairman. Again, Angie Sanders, General Counsel for the board. Presenting on final reading, revisions to the non-public schools approval process rule, and that is 05200702. Tennessee law requires every child residing in Tennessee between the ages of 6 and 17 inclusive to attend a public or non-public school. Non-public schools are defined in the law as including private schools, church-related schools, and independent home schools. This rule establishes the different types of non-public schools in Tennessee, the process for approval of those schools and their accrediting agencies, as well as requirements for the schools and accrediting agencies to comply with. We did, as you may remember, a significant update and revision to both this chapter and another chapter that govern non-public schools, and in that time have received some input from both schools and others who are now starting to implement them with some clarifications. And so additional revisions have been proposed based on that feedback, and there has been some additional legislation in 2023 that we want to address. The changes include clarifying that vaccination requirements do not apply to students who are enrolled in a Category 4 school but educated at home by their parents, and what we commonly refer to as an umbrella homeschool, and that is in accordance with Public Chapter 296 of 2023. We've extended the time for Categories 1, 2, and 5 schools to comply with the requirement to maintain enrollment of at least 10 full-time school-age students to allow them to meet that requirement beginning in the 26-27 school year, so a little bit more of an on-ramp there. We've also added this requirement to the section on Category 3 schools just to maintain a consistent requirement across similar types of schools. requiring all categories of schools to check the Tennessee Educator License Database, otherwise known as TNCompass, to determine if an applicant for a teaching position or any other position requiring proximity to school children has ever had their license suspended or revoked for misconduct. Currently, this is optional. We felt that it was important based on feedback from this board that this be a requirement. And again, it is free to check that. And our team has been in lots of communication and plans lots more to come with private schools around those reporting requirements, including language to ensure schools are aware of the reporting obligations set forth in state law, as I mentioned, and adding additional detail regarding the process for a church-related school to apply directly to the state board for approval. I do want to thank the Tennessee Association of Independent Schools as well as the Non-Public Schools Advisory Council. In addition to our rulemaking hearing, we had a specific meeting with both of those agencies. We did not have any comments at the hearing, but did get some good feedback both from TAIS and the Advisory Council and made a few more edits since first reading. We've retained clarifying language that independent homeschools are not approvable under any of the categories 1 through 5. So that's just making it very clear. Independent homeschools are not regulated by this rule. They are a separate and complete entity. However, we have included language that category 4 umbrella homeschools do fall under that category 4 and trying to bring some clarity there. We have also added language that notes that teaching experience in categories 2 and 3 schools count toward teaching experience for educator license purposes. And we've added language in sections on category 2, 3, and 4 schools to require the department to send annual notice to those accrediting agencies of the state board laws and rules that they are required to hold their schools accountable to. And this was a specific request after a meeting with TAIS around how to ensure that those accrediting agencies are aware of the requirements that they need to be holding their schools to. And this is the language that we came up with. And with that, I'm happy to answer any questions.
We have a recommendation. Is there a motion to accept that recommendation? Mr. Wells moves. Is there a second?
I'll second, and I have a question.
Mr. Mullenhour seconds, and Mr. Mullenhour, you have the floor.
Thank you. Angie, you and I spoke about this leading up to the meeting, but just to clarify for everybody, in the section that addresses category 4 homeschools, the individuals are oftentimes referred to, or the homeschooling parents are referred to as parent-teachers. One of the questions that came up was, well, what if a parent wants to hire a tutor? What if they are engaged in a cooperative, which is fairly common across the state? You provided some clarification for me referencing another statute, but can you just give us just a 30-second to 1-minute overview of how are we making sure that the term parent-teacher in this case isn't limiting the application of this to just the individual who actually does the teaching and gives them the flexibility to hire tutors and to go to co-ops? Thanks.
Yes, thank you for that question. That's a very good question. There is a provision of the law that specifically prohibits the State Board of Education from regulating the selection of faculty in Category 4 schools. So these are those church-related schools. So the law also creates this carve-out for a parent teacher to enroll their child in a Category 4 school and teach them at home under what we call an umbrella homeschool. Given those two requirements, we would not be able to say that a parent couldn't do what you're saying, employ a tutor to help, as long as that Category 4 church-related school is okay with that. So they would need to clear that with the church-related school. That is the authority of that Category 4 school. The state can't regulate the selection of their faculty, and as long as they say parents can employ tutors to help, then it is perfectly fine.
Good question. Yes, Mr. Wells.
I know you can't see me.
All right, Ms. Vanderderf.
I love that you are requiring that all schools look at TNCompass, but how are you following up with that? How do we know that they are actually checking and just not, just saying okay and moving on?
It's a little hard to specifically monitor that. Depending on the category of school, that monitoring and checking is left to the accrediting agency in most cases if it's a Category 2, 3, or 4 school. So that is part of the reason why we included this language that states that those accrediting agencies need to send, that the department needs to send information to the accrediting agencies annually, notifying them of all the requirements and getting a confirmation back from them that they received that, so that they can be ensuring that there's, because that's their job, is to ensure that their schools are complying with these requirements. In most cases, their schools are signing assurances that they're complying with all state laws and regulations that are applicable to their school. So because we are not directly involved here, they are private schools, and we have to recognize that there's agency and that they're independent. We have to rely on, in most cases, the accrediting agencies to be checking up on that. However, because of the reporting piece, there is a requirement in law that directors of these non-public schools have to report to the state board any licensed educator in their building, whether or not they require their teachers to be licensed or not. If that teacher has a license, they're required to report any misconduct to us so that we can consider that for potential license action. Because as we know, they can take that license and go from a private school and get a job in a Tennessee public school. And so we want to make sure that we are capturing those people. So my team, especially P. Danielle Nellis, we are working on an outreach plan to get into the non-public schools to make sure that they understand that reporting requirement. And they're going to have to know who in their building is licensed in order to comply with that requirement. So they will start to see, okay, I need to be checking this. It's a requirement that I check it. And not only do I need to know that, because that's nice to know, right? But I have to know it so that I can know who in my building needs to be reported if something happens.
Mr. Wells.
Thank you. So that portion was something that came out of a situation in my district, and so I wanted to put that in there. You said you got a lot of feedback from non-public schools. Just wondering, was there anything on this that was unintended consequences, or anything that they said on that part about checking TN Compass?
I have not heard significant heartburn about this. I don't know if Mr. Morrow wants to provide his perspective on it, but it is free and easy to check.
No, the specific TN Compass is, I think everybody's in support of. I think adding the language active or expired, right, that's a change that actually, a lot of times independent schools will hire someone with an active license, but because it's not a requirement, they're not going to go through all the hoops to maintain it unless the person just wants to. So, previously, if you had someone on an expired license that was dismissed or needed to be reported because the law said just possesses the teacher's educator license, it wasn't clear. So now having to report both active and expired actually increases the accountability for the independent schools. But I think all the independent schools that we've talked to are like, yeah, we want to make sure that this is again, it's the state's license, right? And so if it's the state's license of that teacher, then there are obligations within the state that we want to support because it's a licensed teacher by the state, active or expired, and so we want to be in compliance with that. So it was actually, that part's pretty well received. I think the other things are just anytime you work with independent schools, it's like, we're not taking public funding, we're not doing any of those things like independence for a reason, and just want to make sure we're in compliance. So then it goes to the accrediting agency, which every independent school is accountable to. And so it's really, I think, the most reasonable and logical way to provide oversight to independent schools that they're doing what they're supposed to do according to the agency that says they are as an independent accreditor that we all have to be in compliance with and send annual updates to.
Mr. Jensen.
A question, clarification. Contract schools, where do they fit in this? And how does that apply, what you talk to apply to them?
So a contract school is not an independent, non-public school, so they would not fall under this rule. A contract school, and I know there are a few that exist in Shelby County currently, are public schools that operate under a contract with the local Board of Education. So sort of similar to a charter school, but still separate and distinct from a charter school. So they would be not subject to these rules.
The success of, for example, the Goodwill Excel schools with contract high school for adults.
Mm-hmm.
I want to make sure we're thinking about that, and because you do have dual enrollment there, and I just want to make sure that we're thinking about that. It's helpful to understand what you did, so thank you.
Other questions? We have a motion and a second then to accept the hearings procedure and public meetings rule. This is on, or the non-public schools approval process rule. This is on final reading. Mr. James, would you please call the roll?
Mr. Cobbins.
Aye.
Ms. Cox.
Aye.
Mrs. Hartgrove.
Aye.
Mr. Holt.
Aye.
Mr. Jensen.
Aye.
Mrs. McInturf.
Aye.
Mr. Mullenhour.
Aye.
Mr. Morrow.
Aye.
Mr. Wells.
Aye.
Mr. Chairman Eby.
Aye.
10 ayes, Mr. Chairman.
Motion passes. Thank you, Ms. Sanders. We'll take up one more item, alternative education program policy repeal. Ms. Kate Sanders.
Good morning, members of the board. I'm here to present the alternative education policy repeal. Currently, the State Board of Education's Alternative Education Programs Policy 2.302 serves to add further detail to the Alternative Education Rule 0520-01-02.09. Language previously contained in this policy is being incorporated into the Alternative Education Rule that was approved at the November 3rd, 2023 State Board of Education meeting. This item repeals the policy because the requirements contained in policy are now duplicative to the requirements outlined in the Alternative Education Rule. No revisions were made between first and final reading. The Department of Education recommends approval of this item on final reading, and the SBE staff concurs with this recommendation. Happy to take any questions at this time.
Thank you. We have a recommendation. Do I have a motion to accept the alternative education policy repeal?
So moved.
Chair Hartgrove moves. Do I have a second?
Second.
Vice Chair Cobbins seconds. Is there any discussion? No discussion. All in favor then for the alternative education program policy repeal signify by saying aye. Aye. Opposed? Motion carries. Thank you, Ms. Sanders. We're going to take a 10-minute break, so we'll 10:31.
10 minutes.
reason. She was attending the National FFA Convention. And not only did she attend, but she came in second nationally with her agricultural proficiency application. And Laurel, can you spend one more minute telling us a little bit more about what that entails? But I know it's a high honor and we're awfully proud of you.
Yes, thank you, first of all. So it was, I believe, 22 to 23 page application. It was really big, of all of my agricultural involvement over 4 years. So it was a lot of writing, a lot of numbers. And once that application competed at the Tennessee FFA State Convention, and I got first here, and then it went on to compete against every other application that was turned in every other state across the nation. I believe 37 other applicants. And of those applicants, the top 4 went on to interview in front of a panel of 10 different judges, where from that panel, the first place, it was scored, of course, down, and I came in second, very closely behind the first place winner.
Again, congratulations.
That is awesome. That is awesome. Okay. Next item is educator licensure policy 5502. Mr. Taylor Reed.
Good morning, Taylor Reed, Senior Director of Licensure for the department. Tennessee State Board of Education Educator Licensure Policy 5.205 further defines Educator Licensure Rule 0520-02-03 and outlines general licensure requirements, including application and duration of licenses, professional development points, and endorsements. This item revises the licensure renewal and advancement section by removing the section in its entirety, as requirements are detailed in Educator Licensure Rule Chapter 0520-02-03. This item revises the endorsement section by allowing a licensed educator to add an endorsement by holding a major in a qualifying area, and clarifies that candidates holding a practitioner-level license enrolled in a job-embedded program shall complete all program requirements prior to adding additional endorsements to the practitioner license. Lastly, this item creates endorsement areas split by K-8 and 612 grade bands for English as a second language, health and wellness education, and physical education to allow the department to better issue equivalent endorsements to out-of-state candidates. As articulated, there have been minor changes to this item since first reading. The Department of Education recommends acceptance of this item on final reading. The SBE staff concurs with this recommendation. And with that, happy to take any questions.
We have a recommendation. Is there a motion to accept the recommendation?
So moved.
A motion by Vice Chair Cobbins. Is there a second?
Second.
Second by Mr. Mullenhour. Discussion. Questions for Ms. Reed? No questions. All in favor then for accepting the motion on educator licensure policy, signify by saying aye. Aye. Opposed? Motion carries. Next item, Ms. Reed.
Tennessee State Board of Education Educator Licensure Rule 0520/02/03 outlines the license types issued in Tennessee and pathways towards licensure. Sections -.03 through -.07 govern the issuance of teacher, occupational, school service personnel, JORTC, and post-secondary educator licenses. Section -.10 governs the issuance of instructional leader licenses. This item revises the requirements for all educator license types to ensure alignment across license types for key transactions. Additionally, this item makes revisions to the requirements for instructional leader licenses to ensure the alignment for license renewal and advancement in accordance with Tennessee Code Annotated Chapter 49-5-5703. This item proposes revisions to requirements for the multiple license types found in Rule 0520/02/03-03 through 0520-02-03-.07 by clarifying the relationship between academic and occupational teacher licenses, clarifying renewal and advancement requirements across license types, aligning assessment requirements to the professional assessments for Tennessee Educators Policy 5.105, and amending the licensure pathways and endorsement requirements to align all license types. This item proposes revisions to Rule 0520-02-03-.10 for instructional leader licenses by amending licensure advancement guidelines to include current tassel hours and the use of out-of-state experience. This item proposes revisions to Rule 0520-02 2022-03-.13 for the limited license to clarify the advancement requirements for educators seeking to advance from a limited license to a practitioner license. Lastly, this item codifies the grace period to renew or advance the applicable license type found in Educator Licensure Rule 0520-02-03-.03 to 0520-02-03-.10 until October 1st following the date of expiration if requirements are met within the renewal period, the validity period, excuse me. State Board staff held a rulemaking hearing between first and final reading to collect public feedback. There were minor clerical revisions between first and final reading. The Department of Education recommends acceptance of this item on final reading. The SBE staff concurs with this recommendation. Happy to take any questions.
We have a recommendation for the educator licensure rule changes. Is there a motion to accept those?
So moved, but I would appreciate it if she would repeat those numbers.
Thank you. Mr. Jensen moves. Is there a second?
Second.
Vice Chair Cobbins seconds. Is there any questions for Ms. Reed on this? This is a rule, final reading, so it will require a roll call vote. Mr. James.
Mr. Cobbins.
Aye.
Ms. Cox.
Aye.
Mrs. Hartgrove.
Aye.
Mr. Holt.
Aye.
Mr. Jensen. Mrs. McInturf.
Aye.
Mr. Mullenhour.
Aye.
Mr. Morrow.
Aye.
Mr. Wells.
Aye.
Mr. Chairman Eby.
Aye.
10 ayes.
The motion carries. Educator licensure rule. I'm not going to go through the numbers. 03, 07, 10, and 13 passes. Thank you. Next item, professional assessments for teacher educator license policy.
Tennessee State Board of Education Professional Assessments for Tennessee Educators Policy 5.105 outlines general assessment requirements as well as pedagogical, specialty area content, and foundational literacy skills assessments. This item proposes a revision to Section 1, General Assessment Requirements, by clarifying assessment timelines and expectations in relation to the Department of Education guidance. This item proposes revisions to Section 3, Specialty Area Content Assessments, by clarifying licensure, renewal, and advancement requirements for educators who hold a major aligned to a qualifying endorsement, identifies assessment timelines for job-embedded candidates, amends assessment codes previously approved by the State Board that were inadvertently left off of the Integrated Early Childhood Pre-K-3 endorsement, and removes teaching reading elementary education test code 5203 as it is no longer accepted as of August 31st, 2023. Lastly, this item removes the requirement for teaching reading elementary test code 5205 for middle grades 6 through 8 endorsements, as the grades covered by the endorsements do not align to the assessment. One change was made between first and final reading. An additional EdTPA assessment option for the computer science K-12 endorsement was added in Table 1. Educators may choose between the two options. The Department of Education recommends acceptance of this item on final reading. The SBE staff concurs with this recommendation, and I'm happy to take any questions.
We have a recommendation. Is there a motion to accept?
So moved.
Vice Chair Cobbins moves to accept. Is there a second?
Second.
Mr. Jensen seconds. Professional assessments for Tennessee educator policy. Is there any questions for Ms. Reed? We have no questions, so we have a motion, we have a second. All in favor signify by saying aye. Aye. Opposed? Motion carries. Thank you, Ms. Reed. Next item, promotion and retention rule. Mr. Powers.
Thank you, Mr. Chairman. My name is Jack Powers, and I'm the Assistant Commissioner of Policy and Legislative Affairs at the Department of Education. And I'm here today to present some changes to the State Board's promotion and retention rule on final reading. And just as a quick recap, the State Board's promotion and retention rule outlines promotion and retention requirements for K-8 students. Specifically, the rule details pathways to 4th grade promotion for 3rd grade students who score approaching or below on the ELA portion of the TCAP. What we're doing here is we're making some changes to this rule in accordance with Public Chapter 338 of 2023. That public chapter included an additional promotion pathway for 3rd grade students who score approaching on the TCAP, on the ELA portion of the TCAP in particular. And what that law said is that starting in 2023-2024, which is this school year, 3rd grade students who score approaching may be promoted to the 4th grade if they score within the 50th percentile on the most recently administered state-provided universal reading screener, and if they are provided tutoring services for the entirety of the fourth grade year. That public chapter also made some changes to the language around the parent appeals process that would allow a school principal or a guidance counselor, a teacher, other staff in the school building to basically assist the parent in filing the appeal, as long as they have written consent from the parent. And again, that is for students who score in the approaching category on the third grade portion of the TCAP. There are a couple of other changes that were made to this rule as a part of this revision process. One of those was specifying that the Department of Education will open the appeals window no later than 5 business days after releasing the individual student TCAP data to LEAs and public charter schools. Another change was it authorized the commissioner to extend the 14-day timeline of notifying a parent or legal guardian of the appeals decision. And then a final one is just clarification of the criteria for an appeal evaluated under Ground 2, which deals with catastrophic situations, and that specified that documentation for an appeal must show a catastrophic situation that occurred on the test date or within 60 days leading up to the third grade TCAP. There was a rulemaking hearing held on this item on December 21st of 2023. Between first and final reading, there were revisions made to this item in response to feedback from board members at the November meeting. That includes removing the current Ground 1 appeals language, which previously was based on the student's performance on a state board approved universal reading screener. Our rationale for proposing the removal of that language was because it is our position that it is inconsistent or in conflict with the new law, Public Chapter 338 of the Public Acts of 2023, which again set the benchmark at 50% on the Tennessee Universal Reading Screener in addition to tutoring. We also made some revisions here to require that LEAs and public charter schools notify all third and fourth grade students of the promotion and retention requirements that were outlined in this rule. And then lastly, we made some revisions to specify that students granted an appeal may enroll in a summer programming or tutoring opportunity subject to available space in their LEA. So again, those additional items I listed there are being proposed between the first and final reading on this item based on feedback that was received. And with that, board members, I stand ready to take any questions that you all may have.
Thank you, Mr. Powers. I will remind people, yesterday we had a very lengthy discussion of this at a workshop, and if those who are watching online, if you haven't seen that, I would recommend that you go and watch that. A lot of questions. As a result of that, we also asked our legal counsel for some advice and for some thoughts about what we're talking about. So before we get into that, I would like to ask if we have a motion to accept the recommendation. Doesn't mean it won't be amended, but a motion to accept so we can get it on the floor for discussion. Is there a motion?
So moved.
Vice Chair Cobbins moves. Is there a second? I will second that motion. Ms. Sanders, would you like to describe kind of summarize what you went home last night and thought about our questions and kind of where you're at, and then.
Sure, Chairman. Thank you, Angie Sanders, General Counsel for the board. Yesterday, I was asked whether or not I agreed with the department's interpretation that the Ground 1 appeal as it currently exists in the rule conflicts with the new legislation. It is my opinion that it does in the form that it currently exists in rule. So the rule currently says a student who scores at the national norm, which the department has said is the 40th percentile, on any of the state-approved screeners can be promoted.
It'll closer to the mic.
I'm sorry.
Sorry.
Is that better?
Yes.
It says that they can be promoted to the fourth grade. The law that was passed said that a student who scores in the 50th percentile on the Tennessee screener, which is one of the state-approved screeners, can only be promoted if they score in the 50th percentile and they get tutoring. So the board has to make sure that its rules are consistent with the law. And we can't create a rule that would conflict directly. And our rules also have to be in line with the spirit and the intent of the law.
And I don't think that it's reasonable to think that the General Assembly, in passing that specific provision, meant that the board could basically nullify that through an appeals pathway. That's not to say that I don't think the board has the power to still establish an appeals pathway that considers universal reading screener data at the 40th percentile in addition to other factors. We would need to make sure that those factors are in addition to and different than what is currently in the pathway that was established by the General Assembly. So some sort of like multiple measures that make you feel better about if this student is performing at the 40th rather than the 50th. What other type of evidence would you need to see in order to say that as an appeal, they could continue to move on? So I think there is still definitely authority. The board has broad authority to establish an appeals pathway, but I think we need to ensure that those appeals are consistent with the law, not only in the letter of the law, but the spirit.
Thank you. So in something like that, and obviously we don't want to make a decision, you know, that has unintended consequences, as Mr. Morrow spoke about before. We want to be very thorough about it, but something on the order like if you had 40th percentile score on the a state approved universal screener, you had then some of these other criteria like 100% unanimous recommendation from the parent, the classroom teacher, or other relevant staff members who can speak to child performance or know of their disabilities. Maybe requiring schools to agree to develop an individualized academic remediation plan similar to what's in our Rule 6G already. And the school would agree to provide fourth grade tutoring. Something like that would be, in your mind, in your opinion, would be something that the board would have authority to do?
I think something like that would probably still be in keeping with the intent of the legislation and the authority that the board has, and not be a direct conflict with the pathway that was established by the General Assembly.
I would like to get thoughts from other board members and et cetera about this process, and also from the department.
Mr. Chairman,
Yes.
can I go first? Could you just repeat it one more time? Could you say that just one more time, what we're discussing?
So what I would likely probably propose as an amendment, but I want to get discussion and obviously think about it before we move forward, is that we would allow an appeal process based on a 40th percentile score of a state-approved universal reading screener. It would have to require 100% unanimous recommendation for that promotion from the parent, from the classroom teacher, and other relevant staff, such as the principal or guidance counselor, or somebody who could speak to the child's performance and would know of their disabilities and be able to input into that. That the school then would agree to develop an individualized academic remediation plan, which would be aligned with the one that we already have in Rule 6G. And that the school would also agree to offer fourth grade tutoring to that student, something like that. From what I understand from speaking with our legal counsel is that we would have that authority if we provided some of these other extra requirements.
Mr. Chairman?
Yes, Ms. McIntyre.
Okay, I really like those recommendations. I was in RTI, I was a teacher for 2 years, and according to the new August 23 updated RTI manual, anybody below 40th percentile is considered at risk, and so they should be. That's not normal. Usually it's below the 25th percentile they get RTI. So I think we need to kind of talk about that and try to get the RTI team, because that, the unanimous parent-teacher, we have that already in the RTI teamwork. We meet every 4.5 weeks. So that's already there. That's not an extra thing we have to come up with. So that works. We just got to make sure that we're serving more kids than that 25th and below. So if we start serving those 40th percentile kids, and that, I think this all aligns to what already is happening. There's already a learning plan for those RTI students. So great job.
Well, just as Ms. Cox is our student member who brings a perspective, you as our teacher member brings an important perspective that the rest of us don't have, and thank you for that comment. Other comments? Mr. Holt, oh, I'm sorry, Mr. Thomas.
Go ahead.
Just on the tutoring aspect of things, I had heard from one of my local districts a concern, one about potentially increasing the volume of tutors required, and whether there would be any consideration of adjusting the required ratio.
Well, I think that's one reason we've got the words here, agree to fourth grade tutoring. We're not stating what that level of tutoring is, are we, or are we? I mean, high dosage, low ratio, or?
That's my question too, back to Angie, is that something that we have the ability to require? Because there is a fiscal implication. The research shows that 1 to 3 is the best ratio for that to be effective. So I have concern about, in some ways, watering down that efficacy for those students by going 1 to 5. I certainly understand what the districts are saying, because I think there is a real fiscal and sort of staffing question.
I am Angie Sanders, General Counsel. So the rule as it currently exists when it talks about tutoring, it defines high dosage, low ratio as being 1 to 3. So if you all say that the tutoring has to be high dosage, low ratio, it would be at that 1 to 3 level. In terms of the concerns, I mean, we certainly have to consider whenever we're making a rule, whether or not that rule has a fiscal impact on local school districts. The language that I heard Chairman Eby state, which is, I think, reflective of the language that's in the current new Pathway 6, is that the school has to agree to provide that tutoring. So it's still that the school has to determine that they would have those sufficient resources. The other thing I want to point out is that regardless of this appeal pathway, a student who scores approaching has the ability to go to the 4th grade by agreeing to tutoring. So those students already can say, I'll do tutoring. The school doesn't have the ability to say, I guess, no in that situation. But by saying the school has to agree to the tutoring, then there's some agency there for the school to say, we're going to sign on to do this and allow you to submit this appeal.
Mr. Holt?
Thank you. I like this proposal. I think it's a good way to handle the situation. I'm glad to hear that we're comfortable with the legality of it. And just to sort of step back, I mean, what the General Assembly added a new pathway for promotion from 3rd to 4th grade. And we had this the appeals pathway that was under discussion to remove, and now we're talking about amending it. That existed last year. So what we're talking about is just, do we leave that in place? And if we do, we need to add some other aspects of it, which is what Mr. Chairman has proposed. And that is raising the bar even a little bit higher. I mean, we're adding a few more requirements than already existed last year. So I'm personally very comfortable that this is in the spirit of the law, that this is not some sort of path around it. We would be, for the same sorts of students who are in that 40th to 50th percentile on a universal reading screener, who advanced through the appeals pathway this past year, they would have an opportunity as well if there was that unanimity among parents, teachers, administrators of the school, and they receive this remediation plan, and they receive the tutoring that they'd receive if it were 50% or above. So I think this is a good way of handling it.
Thank you. I've had numerous discussions with various legislators, and I've watched the videos from the various meetings, and I can't say what their purpose, their intent is, but it just seemed to me that was overall, what this presents as their intent. So I think that they would be, I feel that they would be satisfied with what we're coming up with too.
Mr. Chairman?
Yes. Mr. Mullenhour.
I just wanted to turn the mic over to our commissioner and ask for her perspective on this proposal that's been set forth.
So we will look at it I'll talk to our general counsel on the legality and the operationalization of this. But it is by far the purview of this board to create policy. So we're going to defer to the board on this one.
Mr. Jensen.
Just a comment on this. In the discussions yesterday and then in our workshop and then with the group of teachers afterwards, we're dealing with what we're looking at on the four corners of this document with the consequences of a failure of some sort in K1 and K2. And I'm not asking to address this in this, but I do think somehow the public needs to know that we're aware of that. I'm not sure exactly what the solution is, but that we're dealing with the outcomes in what we're talking about on the four corners of this document from something that did not happen in K1 and K2. And I just think we need to, I want to be on record about that we can, yes, we can do this and we can create this pathway and do this and that, but we're here because we're not getting something done early and recognizing that there's a problem. One of the teachers that was here yesterday, or saw her this morning at breakfast, and she said the young man who was held back in I think the first grade, he was cheering about it in the lunchroom because he was going to get to be with Miss again the next year. So I want to be on record expressing a concern that we're dealing with this, and I'm going to vote for it, but I also want to be on the record saying we need to go back and think deeply about K1 and K2 so that we can help some of these kids not get to this place where we have to deal with this issue. Thank you.
Very good comment, Mr. Jensen. Totally agree, as we've got to address this problem in kindergarten and first grade, not wait till third or fourth grade to address it.
Thank you.
Mr. Mullenhour.
Chairman. So, in principle, I like the proposal. You've made a great case for it. It makes sense. I'm also just trying to remind myself, one of some of the biggest mistakes I've made over time in making decisions is not knowing what I don't know. And this would strike me as an area where it would just be easy for us to not account for the operationalization of it. I think that would be the word. Or to not understand some of the implications that this might have on others. So I'm not disagreeing with it. Conceptually, it makes sense, but I guess my question would be for any of the people on our policy team or on the department's team, if we took this proposal and kind of worked at it a little bit and kind of chased some of the potential outcomes and kind of traced the lines of the implications over the next month or so, do you anticipate that we would arrive at a place where we could confidently say, yes, these are going to be the implications? Or are we sitting here today and we're like, yeah, if we did these things, here's the implications, we kind of know what we're dealing with?
Let me address, up front at the very beginning, I said, I wanted to get us on discussion. We do have a special called meeting in March, and I think the appropriate thing to do is to work it, massage it. I think everyone understands what I'm proposing, but I agree with you. I'm not, the unintended consequences that we talked about before, we need to be sure that we're thorough on that. So, at some point in time, or somebody probably move to table this discussion or move it to the special called meeting. But what I wanted to do was get the conversation out, get the conceptualization out, see if people in general agree with the ideas, and then, as you say, turn it over to the experts. We're not educators, people who understand that better, to come back to us with an official recommendation. Is that okay, Mr. Mullenhour?
Yes, now that I better understand your intent, yes, I think that I would propose that I'll just go and make the motion. I make a motion to table the current proposal.
Let me just say this. If you make a motion to table, we have to automatically vote on table, and there's no further discussion if it passes the table.
Okay.
So we might want to leave it open for discussion and then eventually move it.
Yeah, so I'll cede the floor in anticipation of some more colorful conversation on it.
Mr. Chairman?
Yes.
I do want
Ms.
to
Hargrove.
add my own comments because I did, of course, talk about this in our workshop yesterday. And I think what you have laid out for us really addresses what I think is the right way to approach this. And I mentioned the fact that the parental voice is pretty much left out. And this includes the voice of the parent. And so I'm pleased about that. The other aspect of it is that I've spoken with people in the districts, and they want to be able to have this appeal. We removed it, and they're disappointed that were going to take action to remove the ground one appeal. So to me, it's in keeping with what I think would make sense and what would work. And I understand the concern about any unintended consequences. I do have one question, because this is something that I'm not familiar with, and perhaps Ms. McInturf could help us with this. When we talk about an individual remediation plan that's already in existence, isn't that more like RTI? That's a lot of the RTI equation, and that's a lot of on-the-job, day in and day out, tutoring those children. Would additional tutoring be necessary in an appeal process to add that layer on? Because that could be where the biggest unintended consequences are. Because some of the teachers yesterday were talking about the fact we are doing RTI. We are working with these students day in and day out. That's one. So I'm just questioning whether or not having even the fourth grade tutoring is something that needs to be added in the appeal. So I'm curious to know your
So the only difference would be for this 1 to 3 tutoring in RTI, it's been a few years, but 1 to 5 would be the tier 3, and then like 1 to 12 would be tier 2. So it's a smaller group. So this would be an even smaller group. But I think if we and also there's a case where you'll have a student that was maybe tier 3 in first or second grade, and then they made so much growth, and you write that letter to that parent saying they grew to tier 2, and then you write that letter to the same parents and they grew to tier 1. They don't need RTI because they were in the 30th or the 40th percentile. And I remember putting smiley faces and giving the kids a hug saying they've made it out of RTI. They are in tier 1. And these are the kids that we're looking at saying, but you also failed 3rd grade or 4th grade. Yeah. So we've got to figure out where we can make everything align, because we also have rules and policies about RTI and what is considered at risk. Right. And it's a lot higher than this law. So, okay. But essentially, but yeah, that even in the manual it says that tutoring that 1 to 3 could count in RTI as long as the ratios are 1 to 3.
Okay. I do want to add another thing, because we did talk about this. You brought it up. Some of you have already brought it up today. Obviously, the law is what the law is, and we know we are bound to write the rules and the policy based on that. So this is where I'm pleased that our general counsel has indicated we have this option to move forward. I think it's important, as I think it was Mr. Jensen that says, yes, we have to address the issue with 1 to 2, grade K through 1, K through 2, etc. We had legislators that we had conversations with yesterday, and I think they would agree with that, but right now we're not in a position to address that. We know testing begins in 3rd grade, so that's another challenge. At any rate, I'm pleased with this recommendation that you've put forth. I'm not sure that I'm in favor of tabling. I think it just further delays what we are needing to do, and we have districts who are out there, they're all waiting to know what the final recommendation will be. So I'm not in favor of tabling it, but I do understand the concerns. So,
Mr. Morrow?
Yes, sir, thank you. I just want to, go on record as well. I think the exciting part about this is I've received more emails than I can get back to. And in all of our conversations yesterday in the workshop, with our teachers the afternoon, with legislators, there's such an agreement around wanting to see students succeed in reading, right? So I think that's the beauty of it. There's an aligned desire, regardless of party or perspective, that we want kids to see our kids reading. And I think there's an appropriate, everybody wants to see that there's a hard backstop, right? So there goes the legislation of we want a backstop where, hey, we just can't keep moving people along that can't read, right? So then really I think the challenge for all of us is like, okay, so between the first day you enter school and that backstop, how are we aligning all of these different things, from the percentages that qualify you for RTI, whether it be the 25th percentile or the 40th, where does tier 2 fit in, which then would activate all of these supports that already exist for some students, as well as knowing that we have things available for K1 and 2 that when this legislation was passed, it wasn't available, right? So the universal reading screeners, I mean, the benchmark assessments there's gonna be 9 benchmark assessments between K and 2 if they're doing 3 a year, where you're gonna have information. And so, and I think there's another, a large sentiment that I'm experiencing, which is I shouldn't say that one. Many are not opposed, even practitioners are not opposed to retention, but it's looking at what is the best place for retention to occur and where can early intervention have the greatest impact. And so I think while that doesn't change the situation we're in and what we have to decide on, I just sort of want on public record to say there's a consistent agreement between, I believe, the department, the board, the legislature, that we are all on the same page for seeing students succeed, and really an appetite for everyone to work together on integrating what already exists on behalf of parents and students to avoid, right, this 3rd grade cliff, if you will, or 4th grade cliff. And so I just want to encourage us, while we have to deal with what we deal, just to everybody, like, just because something exists in law now doesn't mean there are not ways to amend or change those things that don't remove any of the work that's been done, but enhance the student experience and the student's educational pathway in literacy that takes advantage of what already exists and it's in place. So, I don't love the idea of it just being like, well, here's your backstop and that's all there is, when we know what we know about, child development, learning, and literacy. So I just want to encourage us to keep moving in the direction of working with the teachers who would say, the earlier, the better. Let's not wait. Let's not give misinformation unintended to families where, hey, you've made it out of tier 2. Great job. You're back in tier 1. That's in the general population. It's tier 1. But you're not going to get a go to 4th grade. So, because that's just a conflicting message. So I think integrating those systems as much as we can, whether it be in rule, in law, or any of those things, we need to continue to pursue. And I appreciate what you have brought up as recommendations for the 40th to 50th percentile is it's giving agency back to families. It's allowing for partnership and collaboration between the experts in the field, which is the administrators, the counselors, and the teachers, and those who love their kids the most, the parents, and making sure they're synced up and giving them that option of this one carve out, which is 40th percentile, the 49th percentile of students.
And it keeps the focus on the students.
Correct.
Good. Other comments or questions? Yeah, Mr. Commons.
I guess I'm not opposed to tabling until our special call meeting. But what I would like is to ensure that with all of this, that the voice and input from the folks who have to implement and effectuate this is garnered in between now and then. I know we've all gotten input and emails and other things from folks with different opinions and perspectives across the board. But hopefully, if and when we come back to this, that those perspectives are baked into what we ultimately decide and what we ultimately vote on.
Let me ask our parliamentarian a question. We have a motion on the floor and a second, and that motion is for the recommendation as presented to us by the TDOE. Obviously, what I've talked about is something that's considerably different than that. Would it make sense for me to make an amendment, see if that gets seconded, and then table that, so at least that gives the people and our staff a basis from which to work for? And obviously, they're going to come back with suggested specific language, or is it best to leave it as it is and just leave it open to them?
Mr. Chairman, I think probably the most appropriate motion is for the board to postpone consideration of this item while simultaneously instructing the staff to work with you to create the amendment. because an amendment offered here and now, it'd have to be written out and done in a very quick period of time. So it's called a motion to postpone with instructions. And so that is a little bit different than a tabling motion, because you wouldn't have to lift it. And then you could consider it at the special call.
Before I make that motion as such, and again, another reason why we have a great staff. Is there any other further discussion on this item before I make a motion to postpone? Yes, Mr. Holt.
Just one quick comment for anyone who's watching, who hears our postponing this, if that's what ends up happening to the next meeting. We're talking about basically 2 weeks. So it's a very short amount of time just to craft the language that we believe would be best for this instead of just putting it through today. And that's based on receiving a lot of community feedback up to yesterday afternoon. So that's the reason why we would be putting this off for a couple of weeks, is just to make sure we get the language just right.
I would say up to this morning. That's a very good point, Mr. Holt.
Mr. Chairman.
Yes, Mr. Mullenhour.
I would also just add to that, and Andrew did a great job of presenting it in this way, but, the position that we're in today is, being made aware that an existing rule is now in conflict with a law that the legislature passed. So an existing rule is in place, legislature passed a new law, now this particular rule that we're talking about is now in conflict. One of the things we've always talked about as a board is making sure that we're working within the bounds that we're supposed to, and that we're backfilling the laws that are passed with the appropriate rules and policies. One of the motivations to address this is the fact that it's currently in conflict with with the legislature's intent.
I want to ask Ms. Sanders, I'm not sure we're in conflict with the law. I think what Ms. Sanders is saying is we have the authority within our responsibilities to change what we want to change. Is that right, Ms. Sanders? I mean,
Angie Sanders, General Counsel, the pathway as it currently exists in the rule does present a conflict with the current law. But of course, we know that this isn't going to go into operation until after these students take this assessment at the end of this school year. So there is time to address this. And certainly a law is always going to trump our rule.
Right.
So there's that.
okay, thank you.
I was just highlighting that, that there's multiple reasons why we want to get this fixed and get it fixed efficiently, on a timely basis, to include, deference to the legislature.
Yep. Any other questions or comments? If none, then I will move to postpone actions on this motion with the intent that our staff will work with TDOE staff and get input within the next 2-week period and bring back to our special called meeting a specific recommendation to meet this intent.
Mr. Chairman, just for the record, could you spell out your intent as well, so we can just go back and see this as
My intent is that we would use a 40th percentile state-approved universal reading screener. We would allow, if there were 100% unanimous recommendation from the parent, classroom, teacher, and other relevant staff members who speak to the child's performance, that the school would agree to develop an individualized academic remediation program aligned with our Rule 6G, and that the school would agree to offer 4th grade tutoring to that student would be permitted to move from 3rd grade to 4th grade. So I made a motion and Mr. Wells seconded. Any further discussion? Yes, Mr. Wells.
Just one thing, and it may already be in the law somewhere else or a rule somewhere else, but that, and I don't know exact language you use, but that other important, what was the language?
Individualized academic remediation plan?
Yeah, but no, you said parents, teacher, and other.
Yeah, other relevant staff members who speak to the child's performance, whether it be counselors or whatever. Do you think we need to specify that?
Yeah, I worry about that a little bit, because it could, who's to say who's relevant?
I'm another person, so I gotta have 100%. That's a good point.
Yeah, and so that would be the only thing, and I think maybe the staff could work with the department to figure out who that is and kind of not leave that so general.
Good point. Any other comments or questions? If none, we have a motion and a second on the floor. All in favor signify by saying aye. Aye. Opposed? Motion carries. Thank you, Mr. Powers.
Thank you, Chairman.
Yes. That did not require a roll call vote.
No, sir. So you're not passing the rule on final reading, so.
Okay. Next item is promotion and retention policy. Dr. David Laird.
Good morning, Chairman Eby, members of the board. I am David Laird, Assistant Commissioner for Assessment and Accountability, and I am here to present on final read Promotion and Retention Policy 3300. The State Board's Promotion and Retention Policy 3300 further defines aspects of Promotion and Retention Rule 0520010316 for 3rd and 4th grade students. TCA 49-6-3115 outlines pathways for a 3rd grade student who did not score proficient on the ELA portion of the TCAP to be promoted to the 4th grade. If a student pursues a promotion pathway involving 4th grade tutoring, the law requires that the student demonstrate adequate growth on the 4th grade ELA portion of the TCAP to be promoted to 5th grade. I do want to highlight as I walk through those steps again for how this calculation will unfold. I am not make particular mention of a number of clarifications and adjustments that have been put in place for this methodology since it was initially presented. We're enormously grateful to a lot of feedback that the department has received from districts and directors across the state, in addition to consulting with members of the state board and the state board staff. So the first step in the process of producing the adequate growth determination is for the department to use the ELA portion of the 3rd grade TCAP results and TVOS growth expectations to compute a probability that the student will be proficient in ELA in the 4th grade. I do want to highlight one adjustment in this step. And again, this was initially serviced by feedback that we received from the field. That initial projection for how likely a child is to be proficient in the 4th grade is going to be calculated now in potentially 2 ways. We will use now either the 3rd grade retake assessment or the spring 3rd grade ELA assessment, whichever one ultimately was higher of the two to produce this projection. So again, that 3rd grade baseline projection will be based on either the retake or the actual 3rd grade spring ELA assessment, again, whichever one demonstrates a higher level of proficiency. And so that is one, we think, very consequential adjustment. I will flag, though, a downstream consequence of that is that information is not yet presently available to districts, as historically the TVOS application did not use the retake results. So this will generally impact about 20 to 25% of the projections for the students that we believe are potentially susceptible to the adequate growth projection. And so the department is already working to update the calculations for these projections, and a complete set of these updated projections and all projections for these students will be provided to districts by February 26th. We'll give them actual Excel files in the accountability application. So again, this does change what they're seeing now, but we will get these updated projections out to districts just as fast as we possibly can. The second step in the process is that students' probability of being proficient in ELA on the 4th grade would then be subtracted from a target of a 50% probability. That 50% number is significant and used in the calculation because that probability percentage at 50% equates to the probability of a student that scores right at the proficiency cut point. So we're essentially comparing that child to the minimally proficient child in the state. We then take the remainder, that gap to the 50%, and we divide it by the remaining years in the TCAP program. Essentially, we pick that number because this is how long we have to track students and ultimately evaluate whether or not the students we say are making growth are ultimately achieving proficiency at some point in time in the future. So then we take where the child's projection was after the 3rd grade results. We take this additional growth target that they're expected to see for increasing the likelihood that they're going to be proficient, and that then sets the target for what we expect them to see after they complete the 4th grade test. 3 additional adjustments specific to the calculation of the 4th grade projection that I want to highlight. The first is that, and we just want to be clear, Any child that actually scores, met, or exceeds expectations on the 4th grade ELA test will have demonstrated adequate growth regardless of what their targets were. Their targets don't even need to be considered in that circumstance. So if you score proficient, you're done. Second adjustment that we make when we think about 4th grade, and I know this is an issue that's been raised by a number of directors and state board staff, folks are aware that the existing TBOS methodology for producing these projections does include multiple subject areas in addition to ELA. There's a strong statistical argument to make that that's an appropriate approach given its role in producing more accurate projections. There's been a lot of concerns raised in a lot of places about the extent to which various pieces of this law require a single test score and the concerns associated with that. Including those other subjects to inform the projections is actually a way to try to counteract those concerns. We know ultimately the error in the measure is reduced when we consider other subject areas. However, as has been flagged for the department, this does create potentially some problematic cases where we might have a student who makes really significant improvement in ELA in 4th grade, but if their other subjects were to drop off precipitously, that growth specifically in ELA may not be as forceful or strong in the determination of adequate growth, and it creates what will certainly be problematic cases for those parents and for those children. And so what the department intends to do in this circumstance is when we're looking at the performance in 4th grade, we'll essentially calculate those projections 2 ways. We'll use all the 4th grade test scores that we have for that child and produce something that we feel like is the best possible estimate for whether or not that child is ultimately likely to be proficient. But we will also calculate that projection just using the 4th grade ELA score so that that score itself stands on its own in terms of the child's progression through the law. That we will then use whichever of those 2 projections is most beneficial to the student, demonstrates the most progress and the most growth. Based on our internal modeling, we don't feel like in the overall application of this methodology that that's going to change things for a lot of students. However, we do know there are some cases out there, things that have been flagged by a variety of folks. There are some use cases out there that would look particularly problematic. And we feel like making this adjustment or this clarification effectively deals with the vast majority of those problematic use cases that potentially exist. And so with that said, I'm happy to solicit a little bit of feedback on the board. As this adjustment is not something that presently exists in policy, the department is happy to open up the floor to potentially considering a policy adjustment, or we can simply handle this on our side in the business rule documentation that we already have drafted and we hope to get out just as soon as we have board approval.
I think it's important to note that this is something that you're just bringing to us now as a result of conversations you've had with the board and with hearing from other things, and I think it certainly is in a positive direction. So,
sure.
Board members, this is the first time you've heard it. First time I heard it was this morning. So, feel free to ask questions.
While they're thinking, so first, thank you, Dr. Laird. I think that makes a lot of sense. I appreciate the thoughtfulness that represents on your part in terms of considering some of the feedback. I'm looking at the rule, and again, this is going to be a question for our general counsel, I imagine, but I don't see anything that is specific to the way that probability is calculated in terms of the various TCAP subjects being used. So I wonder if this is something that could be handled in business rules or if we need to clarify it. So I'm going to toss that over to you, Angie.
Thanks, Sarah. Angie Sanders. Yeah, we don't have any rules or policies that I'm aware of that speak to how those TBOS projections are calculated, and so I think that could remain in department business rules.
Excellent. So one additional adjustment, one final adjustment that the department is proposing, and this is in policy, and again, born out of conversations we had with directors and folks across the state. There's specific concern has been raised about students, the amount of growth that they need to show for students who are already quite close to proficient. So students at the very top of the distribution. And so an additional clarification or an additional adjustment in the policy now is that any student who ultimately would achieve a proficiency target, right, the extent to which they need to show increased likelihood that they're on track for proficiency, if their target is less than 1%, the rule for producing growth for that child would just be to say that they need to be any amount better than where they were in the prior year. And ultimately, we're talking about a very small number of kids. So there's roughly 3 to 4% of the students in the 12,300 kids actually fall within this band. But the department's concern is these are students who are very close to what is objectively a high bar for proficiency in Tennessee. It's always been that way. And so providing a little bit more leniency for these students that are at the upper end of the distribution, we feel is valuable. We also think there's an enormous amount of good for the educators and parents. No one wants to have a conversation with a parent where they're saying the reason why your child failed to make adequate growth is because they needed to make a 0.5 percentage point increase and they only made a 0.25% increase. That is just going to feel wrong. It's going to create for a very difficult conversation to have. And so particularly for students that are at the upper end of the distribution that we know are already so close to proficiency, yes, we are absolutely going to make sure that these kids have done better. But we are going to give them a slightly different target. And again, it's just 3 to 4% of students. It is a very small adjustment in terms of net effect.
Chairman.
Yes, Ms. McIntyre.
So I just want the record to show that there is no pathway for fourth graders that do not show adequate growth. I know that's not on you, that's not on any of us. And I just want that to be clear that we are not voting on that, but I need to share some thoughts on that. As a previous fourth grade teacher, this is gonna be hard. So I've poured over this law and there are so many good things about it. I appreciate all the blood, sweat, and tears our Tennessee lawmakers have put into this law. They truly want what's best for our students. I know that. And they're trying to help every kid succeed. I think the biggest issue for many lawmakers is that they are refusing to allow students to continue to move on if they are not proficient. And I 100% agree with that. My biggest parent critic, this was 10 years ago, her biggest grievance was that I pushed my first graders too hard and my expectations were too rigorous. I'm not one to move the goalposts like some lawmakers have said in their meetings, but I'm also one who has had actual experience in the classroom, and failing a fourth grader is not the answer. This law is so close to being great. The pathway set in place allow every third grader to move on to fourth grade with the supports needed to succeed. Students are getting 1 to 3 tutoring who need it, on top of RTI services if needed, and summer school. All of those things are fantastic. Representative Haston said calling this a retention bill was a misnomer, that their intent was for this to be a reading supports bill. I believe up until the fourth grade growth component, they have done an amazing job getting students the support they need. But unless there is a pathway for fourth graders to move to fifth grade, this will be, in all aspects, a retention law. Students retained in fourth grade will technically move on, though in the same grade and without reading supports. I've also looked at the research on both sides. Tennessee lawmakers should be concerned with illiteracy. There are correlations between low literacy and involvement in criminal activities and have a much higher likelihood of being incarcerated. But on the other side, retaining a student has negative effects as well. Research conducted by the National Institute of Child Health and Development shows that students retained typically show success during the repeat year, but immediately begin to struggle once again when new material is presented in the following years. Struggle, success, struggle again. The gift of time essentially has an expiration date. And for what? Another study conducted a survey of almost 300 students. They were asked to rate 20 most stressful events, by third grade being retained tied with going blind as their top 5 most stressful events. By sixth grade, being retained was the #1 most stressful life event over losing a parent. Studies have also shown that students who are retained are more likely to drop out of school altogether, not to mention the damage to self-esteem and the social and emotional impact on those students. Right now, if a student who does not show growth in fourth grade will be retained, am I correct? Adequate growth.
I believe that's the correct interpretation of the law.
So there is no pathway or appeal for these students. I just needed to get that off. I know that's not you, and you have done an amazing job, and I would not want to have your job right now, but I just wanted to make it clear to those that are listening that hopefully I'm praying that lawmakers will make a different decision soon.
Thank you, Ms. McIntyre. Go ahead, Mr. Laird.
Well, so again, just to summarize, I think what are the most consequential differences based on what the department has said previously. The third grade projections will be based on either the third grade ELA score or the retake score, whichever demonstrates the higher level for the student. Any child in fourth grade that just simply meets or exceeds expectations will be identified as having made adequate growth. In addition, for that fourth grade projection, we'll calculate it 2 ways. We'll calculate it with the all subjects added, trying to potentially limit the impact of a bad day for that student, but we'll also calculate it with just the fourth grade ELA score standing on its own, so that any precipitous growth that we see specific to ELA will obviously propel that child forward. And so with that, the department recommends approval of this item on final reading, and the state board staff concurs, and I'm happy to take additional questions.
We have a recommendation for further discussion. Is there a motion to accept this recommendation?
For further,
For discussion, yeah, we got to get it on.
I'll move to have further discussion.
Yeah, we got, I have a motion and a second. Motion by Mr. Holt, second by Mr. Wilson. Okay. Now, questions, comments, Mr. Holt?
Thank you, Mr. Chairman. And I don't know if I can add much to the importance of the stakes from what Ms. McInturf just said, which I found very compelling. But we're talking about, by numbers as I understand it, somewhere between 6,000 to 10,000 fourth graders right now in the state of Tennessee who, under the department's projections from this standard of adequate growth, would have to be retained under the law. And just the sheer number of students that we are talking about that could have all those consequences that Ms. McInturf was speaking so eloquently of gives me a tremendous amount of pause as well. We met yesterday, as was referenced earlier, with the state's Teachers Advisory Council, who it's a 15 to 20 sort of the exceptional, best of the best teachers from around the state who are handpicked to advise on policy and things just like this. And I was very moved as well to hear how they were saying the same sorts of things that Ms. McInturf was just saying, and how, there can be a lot of value and retention in kindergarten, maybe first grade, but by the time you get to fourth grade, that, the consequences of potential, dropout down the road and things like that are significant. This is not the question that we have before us today on the definition of adequate growth, and I think we all understand that. That's in the law. When I went home last night, I took a look at the enabling legislation for the State Board of Education, so TCA 49-1302, and that's what allows us to sit here today and deliberate and have these discussions. And A1 of that code section says it's the duty of the board, and the board has the power to study programs of instructions in public schools, analyze them, and report to the General Assembly on them. A2 is to set rules and policies. So much of our time here, we're doing that A2, kind of our second role of we're setting the rules and the policies. I think what's pulling us on this is that number one role laid out in the enabling legislation for this board of part of what we are doing when we go to Days in the District, when we hear from the Teacher Advisory Council, when we receive all the emails and talk with constituents, is we are an extension of the legislature in terms of being able to hear things in the community of what is important to do with these laws. And so what I would propose is I intend to bring a resolution at our March 4th special meeting. In fact, two resolutions. The first would be to reevaluate if the state board were to agree that we would propose to the General Assembly a reevaluation of the third grade promotion law to focus and to keep all the good, but to move the time period earlier to kindergarten, first grade, otherwise keep so much of the good of this law, the supports, the additional resources, the accountability that I think we all believe in, but to move it forward to a time period where when this law was passed, as I understand it, we didn't have the universal reading screeners in effect that would allow us to make the assessments necessary to effectuate the law. We now have those in kindergarten and first grade. And so that's something that I'll be working on a resolution on. And then second, and separate from that, which I think maybe is a little more difficult, but I personally believe in, would be a resolution to not to remove the fourth grade retention aspect that we're talking about, but to create additional pathways that already exist in the law to go from third grade to fourth grade. As Ms. McInturf identified, the law allows students through the appeal pathway that we just deliberated, through other pathways to advance from third grade to fourth grade. But then when we get to fourth grade, if they don't meet this definition of adequate growth that we're going to vote on, that's it. They're retained. That's the 6,000 to 10,000 as we currently stand. So that is the second resolution that I intend to bring at the March 4th meeting. As far as what we're doing here today, I think Dr. Laird, I've been able to speak with you one-on-one at length. I think you've done a tremendous job with this task of creating a metric for evaluating adequate growth. As I understand it, though the math is very complicated, it's essentially determining whether these students have closed their own individual gap by 1/8 towards proficiency from when they took TCAP in 3rd grade to when they took TCAP in 4th grade. So it's just 1/8 of the way, which, you know, if we're thinking about what growth means and we want to give it some meaning because it's in the law, that to me strikes me as a reasonable definition, and it's complicated just by virtue of the fact that these are standardized tests, they're scaled, and they're given year over year. But I think that really what we're grappling with is, or at least I'm personally grappling with, is we have this definition of adequate growth, but separate and apart from that, there's the challenges with the law that I think we've all identified, or a lot of us have. So I will stop there.
Thank you, Mr. Holt. I want to follow on with what you said and what Ms. McInturf said by reading an email that I got this morning. This is from an instructional coach. It says, I'm writing to express my concern about the 4th grade retention for 3rd grade students that were promoted to 4th grade on the condition of attending a summer learning bridge camp and having an all-core tutor for the 4th grade school year. Currently, the only way these students can go on to 5th grade is to meet the TCAP adequate growth. I'm working with one of these students. Her name is Kayla. Kayla has only missed 2 days so far this school year, both due to sickness. She's very social, has many friends, and is a leader in her class club. She is engaged in the classroom and completes here assignments, although it takes her longer in class or she does the work at home. She attends tutoring sessions 3 times a week and has also begun an intervention program as part of our school's RTI program. Her parents attend parent-teacher conferences and have asked her for extra work to support Kayla's learning. Kayla and her parents are doing everything they've asked of them, and more to help Kayla succeed in 4th grade. Her last 2 scores on a reading diagnostic benchmark shows that she's performing around the 30th percentile. Unfortunately, it's unlikely that she will be able to meet her TCAP adequate growth to be promoted to 5th grade, and holding her back in 4th grade would be devastating to her. I'm concerned of any self-worth, motivation, eagerness to learn that she will be lost if she's not allowed to move on to 5th grade. To see her friends move on while she's left to repeat 4th grade would do more harm than good. As you meet today to discuss and decide any pathways forwards, I ask that you write Kayla's name on a sticky note in front of you and keep her and thousands of other students in her similar situation in your mind. Thank you for your time and service. So it follows on very carefully with what you're saying and what you're saying.
Mr. Chairman, thank you for reading that. I received that as well. I want to just address what could be a inaccurate narrative coming out of this discussion, which is somehow we're opposed to assessment. I think that instructional coach can write that letter because he knows where she is, and he knows where she is because of quality assessment. And so I so appreciate Mr. Holt, Ms. McInturf, and really share their sentiments. Excuse me. But I just want to go on record saying that I don't hear an opposition of quality assessments to make sure we know where students are learning. And I just want to say thank you to our department for really trying to do the math well. It's taken me a lot of iterations to understand it, roughly understand it. But yet we're really trying to create action. What I hear you saying is we are going to do the math to give every kid a chance. So we're going to look at where do they score higher? Is it with their all subject areas or just their reading in ELA? Are they going to look at their retake? Or are we going to look? So I just see this very shared effort by our department, and really by by our educators. Again, the amazing educators we met with yesterday. And it goes back to what Mr. Holt, I think, is saying, which is there's a much more comprehensive way to look at this, utilizing the resources we have, which include quality benchmark assessments starting in kindergarten. I think as we have these universal reading screeners and these things in place, it actually normalizes assessment for kids. It just becomes another one of the routines. It actually decreases the anxiety about high stakes assessments because it's not just these semi-annual or once a year things we all freak out about, but they're actually sort of regular and normalized, which for a kid that actually helps them because it's not this big scary thing they take once. And so I just want to encourage all of us to, I think, openly talk about assessments, that we're not trying to do away with assessments. We're not trying to do away with the testing. We're actually trying to utilize testing at all ages and stages to make sure that how students are performing meets what I think the intention is again, that students are reading and recognizing the changes through both legislature, Department of Ed, and our board rules that have been that are different from when this legislation was first proposed, which is like we are all, I think Ms. McIntyre said, we are all so close to sort of, I think, potentially making a generational impact on literacy within our state if we can sync up all of these different areas that we're working, from practitioners to legislatures to board members to department, all of those things together. And so I appreciate Mr. Holt wanting to move forward with some resolutions that I think honestly enhance legislation, not reduce legislation, in an attempt to partner more holistically with both lawmakers and practitioners.
Very well said.
Yep, come in.
Mr. Jensen.
First off, Mr. Holt, thank you for going and reading that for us and bringing it to us. I think that it is an overlooked role, and I would characterize it as an advisory role to the General Assembly. And I think the comments that we're having here are valid, and that we ought to fully assess that and make that and adopt a greater impact or greater activity along that advisory. And I look forward to your motion. I appreciate your comments and the passion. And I do think there is another question that needs to be incorporated into what you say, and that is the fiscal impact. The fiscal note that goes with, for example, if we had tutoring at the school level, that there is a cost and a personnel associated with that the legislature, the General Assembly we would need to alert them that that's the reality of what that is if in fact we go down that. So I just think, just as a part of what we're doing, we're calling out the trajectory that we're questioning, but we also need to talk about the associated impacts from a personnel as well as from a physical note on those things.
Mr. Cobbins.
Thank you. Mr. Lair, can you outline for us sort of the ongoing evaluation of this model? Will it be revisited annually? Will it be reevaluated on a consistent basis?
That would certainly be my expectation. There's a couple things that are challenging here, particularly for folks that are trying to redo some of the math. A data point, as the department models this out, that we're looking at is we're looking at, well, in all the different places we could have put the line for adequate growth, what does that actually help us understand in terms of kids actually becoming proficient at some point in time in the future? And that's ultimately, to meet the spirit of the law, something that we're holding ourselves accountable for. We have to put the line in a place where we know that the kids that we're saying make growth do in fact become proficient at some point in time down the road. So we are looking at that over multiple years, and we will continue to reflect on that. The one data point that we do not have is what the impact of the tutoring is likely to have been in Tennessee, and we won't know that until we get the spring scores back. There's a lot of evidence in the research that the high rate or low ratio high dosage tutoring can be incredibly impactful. So we're on the record of writing that our model is likely to produce adequate growth attainment rates of something around 50%. There's definitely some noise in that. It could be higher, it could be lower, but that is assuming everybody just had an average year, that nothing was different for the 12,300 kids that we're going to assess. There's a lot of evidence to suggest that we should be factoring in really robust effect size adjustments because of participation with this tutoring. So the reality is we won't know until we see it. And so I certainly appreciate the comment, and we will certainly continue to reflect after we actually see where tutoring is working, how is it working. We will continue to reflect not just on how we deploy tutoring across the state, but how we're actually measuring adequate growth as well.
Yes, Mr. Cobbins.
I guess, just to clarify, will there be opportunities to make adjustments based on everything that you just said?
I would assume that would certainly be my assumption. I might need to defer to my colleagues, but I think it's critically important that we continue to reflect on how this is going. We've not done this before. And so we absolutely need to continue to reflect on how it's progressing. And if it's not doing what we thought it was going to do, we'll adjust.
Ms. Sanders had a comment.
Yes, I just wanted to make one point of clarification to some of the discussion about adequate growth being the only way for a student to get promoted after fourth grade. That is true with one caveat. The law does say that a student cannot be retained based on their disability or their suspected disability. So there is a carve out in the law for students with disabilities or suspected disability. And so just for those listening, I want to make sure that that's clear on the record.
Mr. Chair.
Yes, Mr. Martin.
It sort of relates a little bit to that. So, and if they've already been retained.
Yeah.
Correct? All right.
Correct.
All right. Speaking of that, so with adequate yearly progress and quality assessments, like I just said, hey, testing actually is important so we know where students are, how they're performing. And in some ways, the more we do that, the better we can assist and intervene and help students close gaps. So for that, what do we do with students who, and the commissioner and I were talking a little bit about this yesterday, just where, hey, you did not perform, you did not make adequate yearly progress in your reading, but you are killing it in math, right? And so when you look at fourth grade, right, they don't have the luxury of a middle school or a high school where you're selecting up in math and maybe down in ELA and you have an honors course here and a college prep course here, remediate. What would how will districts be able to take this information where there is a pretty drastic gap between say math and ELA, where the kid's going to be bored out of their mind if they're doing fourth grade math for the second time, yet going to be challenged in ELA?
So
Maybe that's not the right question for you, but I'm just.
No, I don't want to punt on anything in this space because the conversation is so important, but that really is far more of an implementation issue that is very real for districts. So I'm not trying to dismiss the importance of the question at all. I will say, and we've obviously, as part of this work, looked at it a lot, for most kids, there's an enormously strong correlation between their various subject area scores, but there are absolutely kids out there for which they do perform wildly different. And so there are cases like that, and the hardest part in all of this work is trying to come up with something that we can apply broadly, but is also fair to each individual kid. And so the challenge is definitely real.
And so, and I think the reason that made me think of it is you're like students with disabilities, students with suspected disabilities that this was not applied to. A lot of times you're going to see those drastic gaps within students with disabilities. So I think there's going to be some coverage of that with the percentage of students with that caveat, but just for those that aren't, it's just going to be a unique challenge on schools and differentiated instruction.
Good point. Other comments? Yes, Mr. Wells.
And I know we all want to get something on the record, and I hate to add to that too, but we've received so much on this, and I had a prepared statement, and after hearing Mrs. McInturf, that's not even really needed anymore. She did it so well, but Mr. Holt, I have already set up meetings with my legislators to talk about exactly what you're going to do in a resolution. So I feel like a lot of us are thinking the same way. But I thought of this all night last night, and obviously this morning, like you all have, and received emails through the night and this morning. My greatest mentor that had the most impact on me in life, besides my mother, would be Bill Haslam, and he had two ethos or mantras or whatever you want to say. And the first one was, do what's right always, which sounds really easy, but there were several times in my time with him that I would beg him not to do something because even though it was the right thing to do, it wasn't the right thing politically to do. And the second one he had came from his mentor, Howard Baker, and it was to always consider the other guy might be right. So I just want to put on the record that when this law was going through the process, I was a huge proponent of it. I thought it was the right thing to do, and I thought it was going to set our kids, our children up for success in the future. I was a proponent of it enough that I went on vacation with some friends of mine, and two of them were educators, and they blasted me on this. So I spent time on the beach arguing this and told them why this was a good thing. So in the spirit of Howard Baker, I have changed my opinion on this. I think the intent is correct. I think now that we have more information, now that maybe we have more data for younger ages, that we really do need to reconsider this and look at doing this at an earlier time. So I just wanted to just put that on the record. I've gotten a ton of emails from my district. I appreciate that so much, but this has not been an easy decision for any of us.
Thank you. I think it's important, we hear legislators talking about submitting bills to change laws, et cetera. In fact, we had our Senate budget hearing this past week, and during that budget hearing, this came up, and a couple of legislators talked about that. The problem is the timing, and we have to follow the law. And so with that, certainly, any resolutions you want to bring, and hopefully we can get in and make impacts. But right now, what we have to do is vote on the recommendations that brought to us or amended or whatever.
And Mr. Chairman, before we do that, may I make
Yes.
just a couple of comments? First of all, I do want to say I am so impressed with my fellow board members. You each have articulated some incredibly important points, and there's no way that I would ever attempt to duplicate. And I individually respect you all immensely, so there's no point in even going there. I couldn't do it anyway. You've said it, it's important. One of the things that I want to just ask, and Dr. Laird, I've asked this before because I've had directors ask me, and you all may have already been disseminating some information, but I also know it's been difficult to disseminate when you don't have a final approval. So can you speak to what districts can expect to receive that will help them? Because again, lots of people have said this, it's difficult for people to explain this.
Yep.
And so what might they get? And I will step back and say, one director said, will we get a spreadsheet that we'll just be able to plug some data in and we'll be able to see and be able to use that as a tool to talk to parents about their individual child?
Sure. So we have a business rule document that is pretty much very much ready to be released. Based on some recent conversations, we have a little bit of tweaking to do with that. But I'm sure that we would have a technical document available to the public. If not, even in next week, in the shortened week, certainly by the week after that, we'll have that information available. So all the folks who are trying to recreate what's been done, I think will have what they need to do that. That'll also include an FAQ document, and will be information in there that is more of a parent-friendly version of the frequently asked questions will be part of that as well. A complete set of all of the third grade projections with the targets will be provided to districts by the department on February 26th. So we'll essentially give them spreadsheets with everything recalculated. What they have now is accurate for, by and large, for the vast majority of their students. It's only really the addition of the retake assessment and that best of that is actually going to cause us to go back and recalculate for, again, about 20 to 25% of the students that are going to receive updated projections. We'll have that to everybody by the end of the month. I know Chairman Neame was also particularly interested, well, when will we finally know who made the determination and who didn't? And so there'll be another dump of spreadsheets that will actually have the fourth grade based projection, and will also determine for each individual student who made growth and who didn't. We are right now committed to providing that to districts by July 1st. I know that is far later than anybody would like to receive that information. However, we have to complete all of the scoring of the spring TCAP test. To do that, then comes all of the additional quality control work and production that has to go into actually determining the projections, and particularly given the stakes associated with this, make sure that they're right. So we're tracking a variety of different places in the timeline where we can squeeze out more time. We will do everything that we can to try to get that information to districts ahead of that. But right now, that is the date that we're committed to, so that they'll actually know who's made it and who hasn't by the 1st of July.
I think it's important that we continue to provide information to the parents real time so that come July 1st, there's no surprise. That's the challenge I think we have. And I also think it's important that you talk about a technical document, that's great, but it does have to be in layman's term so people can understand what we're doing, why we're doing it, and where their student fits within that picture. I think those are two really important factors.
Understood.
I was just going to jump in and say thank you so much for sharing that information with us and for what you've done. We know it's been a difficult task that has been put before you and your team, so thank you so much.
And thank you for continuing to look to see how you can change it. These aren't big changes, but they're changes in the right direction, and that was important.
Agreed.
Mr. Mullenhour.
I just want to say thanks to those who have additional context that you guys brought. Some of us come from other industries, sectors. We bring perspective from time to time, but just hearing you, Ms. McInturf, Nathan, I think you also just sharing your frontline experience, and then also the backdrop of Warren and Ryan with your expertise. It's just super helpful. I mean, just listening to you guys really. It's encouraging to me to know that we've got people who are willing to voice their opinions, bring forth those sometimes tough topics, and to help the rest of us catch up a little bit. So thank you.
Any other comments?
Mr. Chairman?
Yes, Mr.
Just
Holt.
one quick point, which is, with the law where it is now on the item before us, if we were not to approve a measure of adequate growth, I don't think that helps at all. As I read the law, the students will be retained unless they show adequate growth on the fourth grade portion of the TCAP. And so by approving this item, it then defines adequate growth such that the students who can meet that will then be moved forward. So I just wanted to point out, because I had received some communication suggesting there would be value to a no vote. I actually think that would be a worse result given where we are today, because then no students would be able to make adequate growth.
Excellent point.
Mr. Chair?
Yes.
I want to I was thinking through this too as an administrator. If no answer or an answer you don't like, I would prefer, give me the worst case scenario and let me start making a plan. So clarity is better than ambiguity. And so I agree with Mr. Holt, just that a no decision actually could be detrimental because you don't know what you're operating with. And if you get a plan you don't like, at least you have something to start responding to with time to do it, as opposed to a delayed response later on.
And we'll have a pathway forward, and if the legislature does make a change between now and the end of session or something like that, then we can take that up at that point in time, but right now we would have a pathway forward. Other questions or comments? If none, we have a recommendation then for promotion and retention policy 3.300. All in favor signify by saying aye. Aye. Opposed? Motion carries. Thank you, Dr. Leary.
Thank you.
Next
Mr. Chairman.
item, charter schools.
Mr. Chairman.
Yes.
May I make a motion? I have to make this during business, and so I thought now after we get through all this weightiness that might be the right time. I would like to make a motion to reconsider item 4H. This is pursuant to our board rules 4.4. 4H is Mr. Milsaint's licensure item. So I think, Mr. Chairman, I'd have to have a second, and I think this body would have to vote to reconsider.
First, let me ask our parliamentarian, is this within parliamentary procedures? He can bring this up at this time?
It is, yeah. He's still within business, and he can move to reconsider, and it's up to the body.
Okay.
I'll second.
We have a motion and a second. Would you like to give some further discussion?
Does the body have to vote to reconsider?
Unless the chair says without objection, so ordered.
Without objection, we'll bring back up item 4H. Go ahead.
So Mr. Chair, on this one, sometimes your Oak Ridge engineer brain's a little faster than my Bedford County Equestrian Center brain. And so I was trying to think this one through. And so just for the body, what my concern is, whether there was ill intent or not on the application for Mr. Milsaint, I don't know for sure. I've looked through the documents, and where I have heartburn, or where my conscience has come back in, is the stipulation of 1 year. And so I would like this body to reconsider that. It's my understanding that he has a couple of pathways, and I may allow Ms. Nellis to kind of talk about those. But as someone who works in the industry where the government sometimes takes away people's livelihood erroneously, I try to think that through a little bit, and I think I worry about putting a stipulation of 1 year on his livelihood here in Tennessee. To be a teacher, we have in some districts teacher shortages, and some others we don't. And so, if I may, can I ask Ms. Nellis to talk about those two pathways of what he could teach right now, and then what he would have to do in Florida to be able to get his license?
Certainly, thank you, Mr. Wells. And I want to maybe take a step back before getting to that question and make sure we're clear that what the board is considering today is whether to accept or deny his application that was submitted November 8th of 2023, which is just a few days past the board meeting that happened. So I gave a lot of information earlier about previous applications, but what we're dealing with at this meeting is a single application. And on that application, he marked the incorrect answer to a personal affirmation question regarding previous denials. And so the board does have a sound basis for denying his application. Separate from that, and not for consideration by our team, is whether he would be eligible, but that is important for context, eligible for a license. And so my understanding, and I'm not a licensed expert, I have Mr. Durline here, and I also have Taylor Reed in the audience with the Department of Education on notice that this might come up. But my understanding is Mr. Milsaint applied for an out-of-state occupational practitioner license and in November of 2023. In order to have an out-of-state application, you would need to have an out-of-state license. And y'all, please correct me if I'm wrong here. He does not have an out-of-state license. He was presented, Florida presented him with information regarding how he might pursue a license in Florida based on the testing situation that he described previously and based on whatever qualifications he does or does not have. My understanding in reviewing the information that he presented is that he would have to complete an EPP in order to get a license in Florida, which he has not done, though he may be in the process of doing. So he not only was denied in Florida, but he has not completed the qualifications to receive a Florida license. And so him applying for an out-of-state license here in Tennessee, he does not meet that minimum qualification of having an out-of-state license. I did check with Ms. Reed during that break to see if he might be eligible for a license here in Tennessee. And so he also has requirements that he would have to submit to even to apply for a license without any of the out-of-state foundation there. If he were just to apply for a Tennessee license or in certain exceptional circumstances have a district apply for a permit on his behalf if he's filling a high need area, then he would have to show proof that he would qualify for those as well. And based on my understanding of the information he has presented, he currently does not qualify for those either. So I hope, Mr. Wells, that answered your question. We are dealing with those two distinct issues. We think we have firm grounding for recommending the denial, but it is always up to the board what you all would like to do with that recommendation, and certainly any modification of that recommendation to deny would be up to you, including removing that stipulation for preventing him from applying for 1 year.
So, Mr. Chair, that's the only part that I want to discuss is the stipulation part. I just don't know if it's needed to be a whole year. I would happy to discuss.
Comments or questions for Mr. Wells or Ms. Nellis?
Question.
Mr. Cobbins.
So what was the rationale for the 1 year? What was the rationale for the 1 year?
Certainly. And this is our first time meeting Mr. Milsaint this morning, and so he provided some additional context that we did not have before. But Mr. Milsaint, in our perception, showed a pattern of behavior of applying consistently without taking care of the underlying need to meet the qualifications. He pushed that personal affirmation multiple times. He presented to board staff, as he termed it, information that showed that he did have a license, though this morning he described it as eligibility, and in reviewing some additional documents, they're eligibility documents and not actual indication that he does have an out-of-state license. And as we have followed up on, he does not have a Florida license. And so it's just that pattern of behavior. We thought it was appropriate to prohibit him from applying over this next year until he took the time to get those things together. However, it may be that this morning, after all this discussion that Mr. Milsaint's been privy to, he understands that he will need to take care of those underlying matters before he submits another application.
How long would it take him to get the EPP? What would be required to get a license? Any estimate on that?
Now that is beyond my scope of knowledge, and I would need to defer to people who deal directly with those programs. Maybe Ms. Reed would be able to answer that?
Ms. Reed?
Taylor Reed, Senior Director of Licensure, Department of Education. On Mr. Milsaint's statement of eligibility, which would make him currently eligible for a temporary 3-year permit in Florida if he were to obtain a position and then pass a fingerprint background check. This is coming from his document that's been uploaded into TN Compass. That would be the equivalent of a Tennessee permit, which we do not reciprocate. In order for him to receive a professional license in which we could reciprocate in the state of Tennessee per the NASU Tech agreement, he needs approximately 6 to 8 courses that are listed out in bullet points. Now that would also depend on the program that he chooses to complete. Some of those bullet points may be covered within one course. So there could be a classroom management. That was one of the bullet points, and there was another one. They could be covered in the same course. However, given the number of bullet points, there would need to be multiple courses in order for him to obtain that Florida license. If he were to come to Tennessee, as Ms. Nellis previously presented, to seek licensure without the Florida license, Tennessee would need to see EPP completion via a recommendation form. And given what we see from the Florida document, we do not believe that is present at this time. However, he would have that opportunity to present that via a form that can be found on our website.
So would you say that having to take 6 to 8 courses, it would likely take him at least a 1-year period to finish those courses?
I would say that's dependent, of course, upon the taker and how many courses they like to take at one time, but 6 courses would be the equivalent of 1 full-time semester student, even above so. I did not personally take any 6 courses in 1 semester.
Mr. Dearline.
Michael Derline, Deputy Executive Director of Policy and Research. Question on this matter, though. Could he enroll in a job-embedded occupational program in Tennessee tomorrow and apply for a license through that pathway?
So yes, he could apply for occupational. However, he has indicated that he's looking for physical education, which for us falls under academic. So he would have to enroll in an academic job-embedded EPP. However, with all of this, even with the application to the job-embedded and acceptance, that is still dependent upon him completing that personal affirmation, which would then place an additional hold on his account, which would end us back with where we currently are.
Other questions? Mr. Morrow.
Just have one question, it might be for council. Is the concern the lack of qualification or the perceived dishonesty and integrity? Like if we were weighing those out, which are the ones that we're really most concerned about? Because I think 2 would have a different direction.
Our action is based on the perceived dishonesty that he, showed throughout this process. And I will say, after he submitted his first application prior to the November meeting, he was in contact with our Associate Counsel Alex Anderson, and/or our paralegal Taylor Bates to indicate why we had recommended denial. And even after that conversation with them, he still marked that question number 5 on the personal affirmation. He still did not indicate that he had a denial.
So you guys worked with him from initial submission, got rejection, and then you kept working with him on or somebody worked with him on trying to fill this out correctly, and yet it still didn't get filled out correctly?
Our contact with him came after he got notification that we would be recommending denial, is my understanding, or the email that is received.
Was there a chance, and I have no idea about the process, so forgive my ignorance, but is there a chance, like, hey, here's denial and here's why? Is there a chance in there of like, oh, my bad, I clicked the wrong box a number of times? Hey, let me go back and change it, or was it kind of like, so there was that opportunity that wasn't taken? I mean, I'd be right. I don't know if you can answer that question.
I
It's just my
can't say
curiosity.
one way or the other. And I think that's a very fair question. What we saw, so the personal affirmation has 5 questions. The first 2 are regarding felony convictions, illegal drug use. He answered no to those. In the first 2 applications, he answered no to that third question, which has to do with suspension and revocation of license. In that November application, he marked yes. So it may have been his attempt to answer the question, but again, the intervening factor there is that he was in conversation about what he did or did not mark correctly, and he had the opportunity to correct that in the subsequent application.
And didn't correct it in the subsequent.
And did not correct it. And this is coupled with conversation regarding his attempt to submit the information indicating that he did have a Florida license. But again, I think as Mr. Mullenhour noted earlier, this is a complex process, and we can certainly understand, granting grace and benefit of the doubt, that there may have been confusion.
Mr. Chairman?
Mr. Mullenhour.
Yeah, a few things. Mr. Wells, I agree with your pause. You know, are we creating a situation where we're taking away someone's livelihood without a full understanding of what might have happened? I also do believe that, and we've talked about this even recently, you know, we want to avoid creating confusion, and we want to make it easy, at least for the applicant, to understand what they're required to do to get a license. The biggest pause that I have in this entire situation is not those things. It's looking at the reasons why he was denied a teacher's certificate in Florida in the first place, which was essentially falsifying a test. He showed up with a pre-written exam. Those are the facts that we're presented with here. I don't think we need to litigate whether or not that is true or not. I think we have to accept the facts as given, and that gives me more pause than any of the rest of it. And you know, I wouldn't be against relieving the 1 year if that was, you know, because there's still a process. There's still requirements that he would have to meet. But I also think we need to be very careful about overlooking the fact that it appears that, and this has nothing to do with the complexity of how our licensing process may be perceived. If you show up at an exam and you turn in work that's not yours as though it's yours, that's a problem, Mr. Wells.
I agree 100%, and that's why I voted that way the first time. But since then, I could be wrong, but I believe he has documentation that maybe not 100%, but has cleared that up. That is not what is holding his license back in Florida anymore. That part, my understanding is he has a letter from stating what he has to do, and that fraud or plagiarism is not on there. And so that is what made me want to reconsider the action, because there may have been a misunderstanding even at that point.
Yes.
Any other questions or comments?
I guess I'll just ask Daniel real quick. So, you know, this letter that we're talking about, have you seen the letter?
Yes, he brought it with him today, and that is, I'm sorry.
Is it your opinion that he falsified the information when he took that exam intentionally?
I cannot form an opinion. I can only go based on the information that's presented to us. We are not an investigative body, as you know, and so we review what is presented to us, and we make our recommendations based on that which is presented to us. And so we have provided the information, as Chair Hartgroves mentioned, for review by this board. Based on our review, it is our understanding that there was fraudulent behavior. We've outlined his interactions with us throughout this process, and so that is how we reached our recommendation. Again, it is rare that we get to speak to educators in this format, and so he is here today. He's provided information that we didn't have previously, and so we would stand by our recommendation, but we also stand here to support the decision of the board in whatever you all choose to do.
Mr. Commons.
In conversation with Mr. Milsank in the break, it's evident that there are things that need to be clarified in Florida first and foremost to create a pathway towards reconsideration. With Mr. Wells's suggestion, I'd just like to know, is there a time frame that you think is reasonable or acceptable, or no time frame, just to get clarification on what you're suggesting?
Thank you. So I don't have a time frame. I thought 3 months, 2 months in my head, but I'm at a point now. I'm not really sure why we put a time frame on there. I think we've told him what he needs to do. He is now educated on that. I don't understand why the time frame is needed in this. Let him take care of his business and come back before us. I want to be very clear. I trust our team immensely, and they do a great job. And this is no reflection on them. I will always lean on the side of trying to give the benefit of the doubt to protect someone's livelihood. And doing that, I trust if he applies again that our team will be there to catch anything that I may be missing right now. But I don't know why the timeline is needed.
So, thank you for that, and it appears to me that if our staff cannot conclude that there was confusion or misintent, that applying a punitive measure seems to be a bit aggressive. And so I would support relinquishing or removing that 1 year stipulation and aligning with what Mr. Wells just said.
Mr. Morrow, just a quick question. So is there a way to flag when so he does all the work, he does all the things, and then would that, because we've had this discussion, would that be flagged before he was licensed in any way, that there would be sort of a reevaluation of all of these things, that showing and documenting what he has done,
Yes.
all of those things in the past?
Yes, and so when he completes his personal affirmation, because at the November meeting his application was denied, and because his application in Florida was denied as well, he will always have to mark on his personal affirmations, based on the questions we have listed currently, that he was previously denied. And when those personal affirmations are flagged, they come to us for review. And so he would go back through this same process. And if those matters are cleared up, considering all of the conversation here, it may be that we recommend that his application be granted, or it may be that we recommend it's denied if there's anything else that is brought to our attention regarding Mr. Milsaint's application.
In that application process, is there a way to sort of put to rest Mr. Mollenhauer's concern of cheating on a test? Like, is there a way to get that sort of formalized from Florida as a part of this, to say, hey, this is resolved, right? Because I think it's a legitimate concern that Mr. Mollenhauer has, like, below all of these things, like there was this, and if he has evidence to the contrary, I would just love to see that, if it's possible, as a part of this, that, hey, this wasn't fraudulent, this was actually something else. Is that possible?
So my general understanding of our process, and I'm going to look over here to General Counsel Angie Sanders, as I'm only about 6 months in at this point, is that we look to the actions of other states when people apply for their out-of-state license, right? That pathway. And so there is generally reciprocity based on the action of other states. So if they have determined that this matter is sufficiently cleared in Florida, we will generally lean into the fact that they have determined that he is able to be licensed in Florida, and then we would act accordingly.
And I don't think we want to open the door where we go to every state and try to track down a situation for each individual. That's a concern I have, is going back to unintended consequences, et cetera.
And I will say, we do inquire. When there are things that are flagged, we will ask for supporting documentation from other states. And so in this situation, I imagine if nothing else comes up, they would submit similar documentation to that which we have already received. Because of the robust conversations that's happening right now, it appears to me that this board would, if he's able to meet all the requirements, be willing to grant his application. And so we would certainly consider that in making our recommendation to this board.
Do we know if Mr. Milsaint has applied for a license, another license in Florida recently, or?
I don't believe he has. I believe the most recent letter says that he is eligible for application and that he has underlying requirements that he has to meet. And so I'm not aware of that. I know that he has been in Tennessee at least a good portion of the first semester of last year for looking at his school calendar, and that he was temporarily employed with Metro Public Schools. And so based on his behavior, it appears that he intends to be here in Tennessee, and so he may choose an alternate pathway.
Mr. Wells?
So thanks everyone for indulging me on this time. I know we've had a weighty meeting already and taken a lot of time, so thank you. And I just want to give him all the tools he needs to do it, whether he does them or not, and whether we choose to allow him to have a license at that time is a whole other story. So my motion would be to remove the 1 year stipulation from the recommendation, but keep everything else.
We have a motion on the floor. Is there a second to that motion?
Second. I'll second.
We have a second. Is there further discussion? Mr. Mullenhour seconded.
I'll second.
So the motion is to remove the 1 year stipulation on the denial for Mr. Milsaint, which means that he could apply whenever he wants to apply, but he would, to get a license, he would still have to meet all the requirements for the application that he's making.
Yes.
Mr. James?
Mr. Cobbins.
Aye.
Ms. Cox.
Aye.
Mrs. Hartgrove.
Aye.
Mr. Holt.
Aye.
Mr. Jensen. Mrs. McInturf.
Aye.
Mr. Mullenhour.
Aye.
Mr. Morrow.
Aye.
Mr. Wells.
Aye.
Mr. Chairman Eby.
Aye.
10 ayes.
Thank you, Mr. Chair.
All right, back on our schedule, next item is, let's see, we're up to the charter schools rule, is that right?
Good morning, Mary Ann Dursky, CFO for the Department of Education. Tennessee State Board of Education Charter Schools Rule, Chapter 0520-14-01, outlines the operational elements of charter schools, including approval of charter schools, allocation of state and local funds, and enrollment processes. Rule Section .01 details the process for the approval of new charter schools. Section .03 details the allocation of state and local funds to charter schools, and Section .04 details enrollment for charter schools. This item proposes the following revisions to approval of Charter Schools Rule 0520-14-01-.01. Clarifies language throughout the rule to distinguish between the steps that must occur during the initial application process and the amended application process. Clarifies the requirement that a local board of education shall include reasons for denial of an initial charter application. Further alignment to the application process outlined in the state board's quality charter authorizing standards. This item also proposes the following revisions to the allocation of state and local funds, Rule 0520-14-01-.03. Clarifies that initial allocation of funds for public charter schools shall be set forth in the local Board of Education's budget that is submitted to the department. For the purpose of initial allocations, requires the department to pull information on the charter school's average daily membership and student counts from the state-approved LEA budget and include funds in initial and funding estimates shared with authorizing LEAs and public charter schools. For the purpose of interim and final allocations to public charter schools, clarifies that the final average per pupil funding amount is based on the LEA's final expenditure report submitted and approved by the department. Requires the department to report to each authorizer and public charter school The final amounts to be paid to the charter school within 5 business days of the state's approval of the LEA's final expenditure reports. Revisions also require LEAs and public charter schools to process final payments within 30 calendar days of the department's report on final amounts. Finally, this item proposes the following revisions to Enrollment Rule 0520-14-01-.04. Aligns the language in the rule with Chapter 206 of the Public Acts of 2023, which authorizes a charter school to give enrollment preference to students who are economically disadvantaged and preference to children of an employee of a charter school. State Board staff held a rulemaking hearing on December 21st, 2023. No comments were submitted at the hearing. However, informal feedback was received from the Tennessee Charter School Center. Between first and final reading, revisions were made to align the rule with Tennessee Code Annotated 49-13-112A3 to specify that authorizers shall include all calculations used in allocating local funds to charter schools in their local budgets submitted to the department. Tennessee Code Annotated 49-1-212 requires that the department prepare a fiscal analysis of any policy, rule, or regulation proposed to the State Board of Education. This item has no financial impact on an LEA. This item supports the State Board's strategic focus on engagement and accountability outlined in the master plan by further clarifying specifics for charter schools and authorizing LEAs in implementation of this rule. The Department of Education recommends approval of this item on final reading. The State Board of Education staff concurs with this recommendation.
Thank you, Ms. Dursky. Do I have a motion to accept the recommendation as presented? Moved by Mr. Wells, second?
Second.
Mr. Holt, seconds. Any questions on the charter school rule? No questions. Mr. James, you want to call the roll?
Mr. Cobbins.
Aye.
Ms. Cox.
Aye.
Mrs. Hartgrove.
Aye.
Mr. Holt.
Aye.
Mr. Jensen. Mrs. McInturf.
Aye.
Mr. Mullenhour.
Aye.
Mr. Morrow.
Aye.
Mr. Wells.
Aye.
Mr. Chairman Eby.
Aye.
And ayes.
Motion passes. Thank you, Ms. Dursky.
Thank you.
Next item, graduation substitution policy, Ms. Wall.
Thank you, Chairman. Good morning, board members. Christy Wall, Assistant Commissioner for the Department, Academics and Instructional Strategy. We've got the Graduation Substitution Policy 3.103. The State Board's Graduation Substitution Policy outlines allowable course substitutions for the graduation requirement credits. This item revises the policy to clarify that students' 4th credit of math or 3rd credit of science is not required to be completed in the student's 4th year of high school or 3rd year of high school, respectively. The revision clarifies that students may complete their required 4th credit of math or 3rd credit of science at any point during high school, as long as they meet the course requirements outlined in the State Board of Education graduation requirements, Rule 0520-01-03-.06. This item also makes minor clarifying edits to the final course substitution descriptions for English 3 and 4, along with personal finance. Between the first and final reading, revisions were made to clarify the allowability for JROTC 1, 2, and 3 to substitute the lifetime wellness, physical education, and personal finance or U.S. government and civics based on feedback from districts. Revisions specify that students may substitute JROTC 1 for 1 credit of lifetime wellness, JROTC 2 for 1/2 credit of physical education, and JROTC 3 for 1/2 credit of personal finance or 1/2 credit of U.S. government and civics. The Department of Education recommends approval of this item on final reading, and the State Board staff concurs with this recommendation. Happy to take any questions on this particular item.
Thank you, Ms. Wall. Do we have a motion to accept the recommendation as proposed?
So moved.
Mr. Holt moves. Do I have a second?
Second.
Second. Any questions for Ms. Wall? No questions. All in favor then for accepting the graduation substitute policy 3.103 signify by saying aye. Aye. Opposed? Motion carries. Thank you. Next item, Mr. Durline.
Michael Durline, Deputy Executive Director of Policy and Research with the State Board. At long last, you have the Tennessee Academic Standards for Social Studies before you on final reading. As you know, the State Board is responsible for facilitating review of core academic content area standards, and in June 2022, the State Board began that review. After 2 rounds of significant public feedback, revisions by expert educators, the Standards Recommendation Committee, which is appointed by the Governor, Lieutenant Governor, and the Speaker of the House, the SRC provided recommendations during their September 28th, 2023 meeting. The co-chair and chair of the SRC also wrote an executive summary, which you have in your materials. In addition, we've created a crosswalk that will allow teachers to understand the shifts that have been made. You also have a summary of the key changes on your cover sheet. And I did want to note that on January 30th, 2024, the SRC held a special called meeting to discuss a recommendation made by the chairman of this board to consider a standard on George Washington that was included in the current standards but omitted from the proposed standards. The SRC voted to include this standards in the proposed standards, and so what is in front of you reflects that change. Also, just to give you some information about the timeline, if you all do approve this on final reading, next year, 2024-25, the Textbook and Instructional Materials Commission will review materials that are submitted. In 25-26, there will be the local adoption of materials, and in 26-27, the standards will be implemented. With that, I'm happy to take any questions you may have.
Thank you, Mr. Durline. I will make the motion to move to approve these standards as presented and looking for a second.
Second.
Chair Hartgrove seconds. Questions or comments for Mr. Durline? I would like to make a couple of comments. First, I'm very pleased to see the new standards of Scarborough 85. This recognizes that my town of Oak Ridge actually was the first town in the southeast to desegregate in 1955, a year before the Clinton 12 and 2 years before the Arkansas 9, when 85 students went from the Scarborough community to the Oak Ridge schools, to the Robertsville Junior High School and Oak Ridge High School. And I know that town is very, very pleased to have this in the standards. I would also like to thank the Teacher Advisory Council as well as the Standards Review Committee. If you've never sat through those meetings and looked at the volumes of information that they go through and the number of standards and deciding, and this one was particularly interesting, do you move 3rd grade, 5th grade history, Tennessee history? Where does all this stuff go? And the conversations and the discussions and the questions really is an amazing process. So thanks to our staff for supporting that, but particularly, and I think we're going to recognize them with a letter or something for their efforts. Just outstanding efforts in going through that. So, Ms. McInturf, yes.
I want to second that. I looked at the standards and where I've taught 3rd, 4th, 6th grade. I mean, especially with the moving geography to 5th grade, it just makes sense. So thank you, everyone that had input on that. Great job.
I got a note here from Nathan says the legislature had asked for the Tennessee history to be placed where it is, saying that they would pass a law to make that happen. We worked with SRC to make it happen before it became law. It was a great example of partnership and should be called out. So good example of working with the legislature. Great. Any other comments or questions? We have a motion and a second. All in favor then for accepting the social studies standards, signify by saying aye. Aye. Opposed? Motion carries. Thank you. Next item, education preparation providers, Ms. Amos.
Thank you all. Brooke Amos, Assistant Commissioner of Human Capital with the department. In accordance with State Board Rule 0520-02-04-.04, this item contains action recommendations for educator preparation providers, EPPs, and specialty area programs, SAPs, for 3 existing EPPs, Tennessee State University, Johnson University, and Maryville College, and 1 prospective EPP, Hamilton County Schools. The results of these recommendations before the board today come after the results of rigorous comprehensive reviews and initial program reviews. The overview of those processes can be found in the cover sheets. I would like to take just a second to say thank you to the individuals from EPPs, LEAs, and our education preparation team who work to ensure that these processes happen with fidelity. I will now share the recommendations from these reviews. The Joint CAPE Accreditation and State Specialty Area Program Comprehensive Review for Tennessee State University. The department's recommendation for the EPP, probationary approval, major stipulations, for the SAPs, full approval, minor stipulations. This joint CAPE state review took place in spring 2023. The review team concluded that the EPP meets expectations on CAPE standards 1 through 4 and does not meet expectations on CAPE standard 5. Some major stipulations were cited. Minor stipulations were also found within the standards. Because the provider met expectations on 3 or more standards but fell below expectations on 1 or more standards, the provider is recommended for probationary approval, major stipulations. The provider is recommended for full approval, minor stipulations for all specialty area programs. For the state-managed EPP and SAP comprehensive review, Johnson University, the department's recommendation, EPP, at the EPP level, probationary approval, major stipulation. For the SAPs, full approval. This state-managed full approval review took place in spring 2023. The review team concluded that the EPP meets expectations on CAPE standards 1 through 3 and does not meet expectations on CAPE standards 4 and 5. Some major stipulations were cited. Minor stipulations were also found within the standards. Because the provider met expectations on 3 or more standards but fell below expectations on 1 or more standards, the provider is recommended for probationary approval, major stipulations. The provider is recommended for full approval for all specialty area programs. Related to both Johnson University and Tennessee State University, pursuant to State Board Rule 0520-02-04, .04, an EPP issued probationary approval may recommend candidates for licensure, but shall submit to the department an improvement plan for addressing the areas in need of improvement within 3 months of receiving probationary approval status from the state board. Each year, the EPP shall present evidence that the provider is implementing the improvement plan and making progress toward meeting expectations. The EPP shall also participate in a focused review within 3 years of receiving probationary approval. Additionally, the EPP shall report on the progress made in each area of deficiency on their annual report for 3 years following the issuance of probationary approval. We will now move to EPP status changes. For EPPs with full approval minor stipulation status, the department may recommend to the board the removal of those minor stipulations for the remainder of the approval period if the EPP has adequately addressed those areas needing improvement. For Maryville College, the department recommends full approval. Department reviewers evaluated the EPP action plan and the subsequent evidence provided during the annual review progress monitoring that has happened since 2020. The department has concluded that the EPP now meets expectations in the areas previously denoted as needing improvement and recommends removal of the minor stipulations. The provider is recommended for a status change to full approval. We'll now discuss new EPPs seeking initial approval. Individual EPPs seeking initial approval may either be granted initial approval or denial of initial approval. Hamilton County Schools is seeking initial approval as an EPP, and the department recommends that as an overall EPP, they be granted initial approval, and that for their SAPs, they be granted conditional approval. The Department of Education reviewed the Hamilton County Schools proposal as a initial provider, and that the SAPs in multiple endorsement areas. The department review team concluded that the Hamilton County Schools meets expectations on the initial EPP proposal and shall be granted initial approval to proceed with the implementation of their new EPP and recommend educator preparation candidates for endorsements in multiple program areas. Hamilton County Schools is therefore recommended for initial approval. Pausing for a second here. Additional updates. On August 29th, 2023, Lemoyne-owned college submitted a formal letter to the department indicating they were voluntarily closing their EPP program effective immediately. Upon the receipt, the department submitted to Lemoyne-owned college an acknowledgement letter detailing the parameters for voluntary EPP closure. Lemoyne-owned college has indicated that they will be reapplying in a future cycle for initial approval as an EPP. If Lemoyne-owned college elects to reapply as an EPP, they will be required to submit a new EPP proposal in accordance with the State Board of Education Educator Preparation Rule and Educator Preparation Policy 5.504 to receive initial approval from the board. The Department of Education recommends approval of this item on first and final read, and the State Board staff concludes. Thank you all, and I'm happy to take any questions.
Thank you, Ms. Amos. We have a motion on the floor for recommendation.
So moved.
Mr. Morrow moves. Do we have a second? Mr. Wells seconds. Questions for Ms. Amos and Mr. Cobbins?
Just one comment. Was saddened to see Lemoyne-Owen remove itself, but understand that it's had some leadership challenges in recent years. But as an institution, it has a long history of producing African-American teachers for decades. And so hopefully as the leadership situation stabilizes, as they intend to reapply, that they can get back on track with that. But that's one of Memphis's most historic college institutions.
Yes, we appreciate that comment and agree and have, the support of the department behind them, and also have collaborated with a third-party group that specifically works with minority serving institutions to provide support to EPPs across the state with their programs.
This is an important function, and we certainly appreciate TDOE's due diligence in doing this. Other questions or comments? We have a recommendation and a motion and a second. All in favor signify yes by saying aye. Aye. Opposed? Motion carries. Next item, health education standards. Thank you, Ms. Ames.
Good afternoon. It's not morning anymore. I'm Melissa Furmeister, and I'm the Senior Manager of Healthy Schools in the Division of Coordinated School Health at the department, and I'm here to talk about health education standards. TCA 491302A8 authorizes the State Board of Education to set policies governing all academic standards and courses of study in the public schools. Additionally, State Board Rule 0520-01-03-.031 calls for the State Board to adopt standards for each subject area, grades K through 12. The approved standards are to be the basis for planning instructional programs in each local school system. The Tennessee Department of Education proposed and the State Board of Education approved on final reading revisions to the health education standards at the November 3rd, 2003 quarterly meeting. Upon approval of the standards, it was determined the safety/passenger safety standard subcomponent was inadvertently removed from the health education K through 5 standards on final reading. This item reintroduces the safety/passenger safety standard subcomponent to the health education K through 5 standards. This item also makes minor formatting revisions to the health education 6 through 8 and 9 through 12 standards. The Department of Education recommends approval of this item on first and final reading. The State Board of Ed staff concurs with this recommendation. Any questions?
Thank you. Do I have a motion to accept the health standards?
So moved.
Second.
Motion by Vice Chair Cobbins, second by Chair Hartgrove. Any questions? I would just say I'm glad to see the emphasis on safety and mental health. I think it's great.
Absolutely. We agree.
No other questions? All in favor signify by saying aye. Aye. Opposed? Motion carries for the health education standards. Thank you.
Thank you.
Now we get into some really good stuff. Reward school designations.
First time. Thank you. So good afternoon, everyone. My name is Shangye Ho. I'm the Senior Director of Accountability at the Department of Education. I'm here today to present the State Identified 22-23 Reward School designations. In accordance with TCA 49-1-602, the Tennessee Department of Education is in charge with presenting to the State Board of Education a listing of reward schools. Reward schools are presented to the board every year. For the 22-23 school year, reward schools are those that have an overall visual accountability score greater than or equal to 3.1 out of 4. This metric is based on performance of all students on each indicator and performance of historically underserved student group on each indicator. Reward schools demonstrate excellence in achievement and growth for all students as well as all student groups. And I'm going to briefly talk about indicators we use for the visual accountability system. That include achievement and growth indicator, reflect the proportion of students meet content standards and whether students are making excellent academic growth. The chronically out of school indicator measure the proportion of students missing 10% or more of the school year. The English language proficiency indicator evaluates how students with limited English proficiency are improving with their language fluency. For high schools, there are 2 additional indicators, including graduation rate and ready graduate rate, which evaluates whether students are earning regular diploma on time and whether they are prepared for post-secondary success. This item has no financial impact on an LEA. The Department of Education recommends approval of this item on first and final reading. The State Board staff concurs with this recommendation. Now I'm happy to take questions.
Thank you. Can I have a motion to accept the reward school designations?
So moved.
Chair Hartgrove, Mr. Holt, was that you? Oh, Mr. Jensen, second. Mr. Jensen, seconds. Questions or comments? I'll just say congratulations to these reward schools, outstanding, and keep up the good work. All in favor then for accepting the recommendation tonight for these reward schools signify by saying aye. Aye. Opposed? Carried. Next item now, even more.
Again, my name is Dr. Shangye Ho. I'm a Senior Director of Accountability at the Department. And the next item I'm going to present is the State Identified 22-23 Exemplary District Designations. In accordance with TCA 49-1-602, the department is announcing the exemplary district designations every year. And for the district designation who are named as exemplary, there are various factors factored into it. So overall indicator score from the 22-23 accountability calculation average the number of points district receive for value-added performance with a higher number of points between their annual measurable objective targets and their absolute performance. So these indicator scores are weighted to calculate an overall all student score. This process is repeated for all the student subgroups as well. District with a final overall weighted average score greater than or equal to 3.1 out of 4 points receive a determination of exemplary based on the 22-23 school year data. And I'm going to quickly review the indicators used in the evaluation. There are 3 grade band success rates reflecting the proportion of students meet content standards and whether students are making expected academic growth among the grade band. The 3 grade bands are grade 3 to 5, 6 to 8, and 9 to 12. And the next indicator is a grades K to 12 chronically out of school indicator, measures the proportion of students missing 10% or more of the school year. Grades K to 12 English language proficiency assessment indicator evaluates how students with limited English proficiency are improving their language fluency. Finally, the graduation rate indicator assesses whether students are earning regular diplomas on time and whether they are prepared for post-secondary success. This item has no financial impact on an LEA. The department recommends approval of this item on the first and final reading. The State Board staff concurs with this recommendation.
So we have a recommendation for naming, I think there's 12 school districts as exemplary. Do I have a motion to accept that?
So moved.
Vice Chair Cobbins moves. Do I have a second? Ms. McInturf seconds. Any further discussion or comments?
Comment.
Yes.
I should have asked this after the first group, which I totally forgot what they, reward schools, apologize. What's the methodology used to disseminate this information to the districts? I mean, do they find out today, or do they already get?
They see the information. This is part of the state board meeting agenda, so they already see the list that's been released on the website as an agenda. But we do, we will send out an email to the directors of the schools, and then they will receive this notification today officially this afternoon.
Just wanted to clarify, because I did have some board members, directors of schools tell me, I saw that I'm on, my schools are on the reward list and it's on your website. I said, yes, and I wasn't sure if they would have heard that first from you all, but of course you were waiting for our approval, so I get that,
Yes.
I understand. Okay, thank you.
Thank you.
Mr. Morrow? No. Any further questions or comments? All in favor then for accepting the exemplary district designations signify by saying aye. Aye. Opposed? Motion. Next item, and those in need of improvement districts.
Again, Dr. Shanya Ho, Senior Director of Accountability at the Department of Education. The final item I'm going to present today is the state identified 22-23 in need of improvement district designations. In accordance with TCA 49-1-602, Tennessee's accountability system as approved in its Every Student Success Act plan, the Tennessee Department of Education is in charge with presenting to the State Board of Education a listing of districts identified as receiving the lowest accountability determination. This information is presented to the board annually. For the 22-23 school year, the lowest accountability determination for district is in need of improvement. District receiving this designation when their overall final score calculated for the 22-23 school year fall in the bottom 5% of all districts. Overall indicator scores from this year's data average the number of points district receive for value-added performance with their higher number of points between the AMO targets and their absolute performance. These indicator scores are averaged to calculate the overall all student score. This process is repeated for all eligible student groups. District will receive an in need of improvement designation if their overall score fall in the bottom 5% statewide, regardless of what the determination score would be according to the weighted average of the final score. An overall score in the bottom 5% outweighs the score determined in the final determination scale in the 22-23 district accountability data. I will quickly review the indicators that use in the evaluation. There are 3 grade band success rates reflecting the proportion of students meet content standards and whether students are making expected academic growth among the grade band. There are 3 grade bands, grade 3 to 5, 6 to 8, and 9 to 12. The next indicator is grades K to 12 chronicle out of school indicator measure the proportion of students missing 10% or more of the school year. Grade K to 12 English language proficiency assessment evaluates how students with limited English proficiency are improving their language fluency. And the final indicator is graduation rate indicator evaluates whether students are earning regular diploma on time and whether they are prepared for post-secondary success. There's no financial impact on an LEA. The Department of Education recommends approval of this item on first and final reading. The State Board members, the State Board staff concurs with the recommendation.
Thank you. We have a motion to accept the needs improvements designation.
So moved.
Vice Chair Cobbins moves. Do I have a second? Second by Mr. Wells. Is there any discussion? No discussion. All in favor for accepting this listing signify by saying aye. Aye. Opposed? Motion carries. Thank you.
Thank you.
And the last item, Mr. Allie Reed.
Good afternoon. Allie Reed, Director of Engagement and Accountability for the State Board, presenting today on first and final reading our 2023 Charter School Authorizer Evaluation Outcomes. We discussed this pretty thoroughly yesterday during our workshop, so I'll keep this brief. The 2023 evaluation process included authorizers from cohort 1, which includes Hamilton County Schools, Knox County Schools, and Memphis Shelby County Schools. These items include the authorizer's evaluation reports, which detail the ratings, provides feedback, and the overall follow-up actions as needed. You are voting today to approve these overall ratings for each of the 3 evaluated authorizers. And our authorizers had an opportunity to review these reports in advance to provide any final feedback, and these will be posted publicly on the State Board's website for further review. This item also supports the State Board's focus in the Master Plan on Engagement and Accountability, as charter school authorizers are held accountable to the State Board's quality authorizing standards. Happy to answer any questions.
Thank you, Ms. Reed. Can I have a motion to accept the authorizer evaluation 2023 outcomes?
So moved.
Mr. Morrow moves. Do I have a second?
Second.
Chair Hartgrove seconds. Questions, comments? This is one I asked yesterday at the workshop, but I'd like to ask it on the record. So as we do these authorizer evaluations, we score them, are we going to be tracking how the overall achievement of the individual schools that they authorize are performing?
Yes, as we continue to see outcomes each year from our authorizers, we will be looking for correlations on charter school progress and growth and success as well.
Hopefully, based on what we do here, gets translated and moved down to the actual schools and the students. Thank you for everything that you and your team do. I mean, this is a very thorough analysis and evaluation as we carry out our role as the authorizer evaluator. So thanks for your team. We have a recommendation. We have a motion and a second. All in favor then for accepting the authorizer evaluations 2023 outcomes signify by saying aye. 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 Opposed? Motion carries. That completes our final reading items. Next is other business. Director, do you have any comments?
I can't say I have much coherent thought left, but I will say we will be busy in the ensuing weeks before our special call meeting. So I just want to go on record myself as saying how appreciative I am of the thoughtfulness, the level of care that our board continues to show to these really difficult decisions and our partnership with the department.
Absolutely. Any board members have any final comments? I too just want to thank each one of you for your efforts. You know, I think that we work together as a team, and we value the independent comments of everybody, and then we come and we speak together as a unit. And I thank you for each one of that. So with that, no other objections, meeting is adjourned.